26 passed by the learned civil judge senior division Saraidev at Sonari in Mijje case number 6 of 2025 arising out of notice number 2 of 2022. It is to be noted here that by the impugn order dated so the learned trial court has set aside the ex parte order and decree passed against the respondent herein on payment of cost of rupees 4,000. Mr. Metro Learned Counsel for the petitioner submits that the learned trial court has arrived at a finding that the summon was not duly served upon the defendant stroke the respondent hearing. However, taking this court through the annexer 10 at page number 132 and 133 submits that annexer 10 is the RTI reply furnished by the Superintendent of Police and CPIO Gwalpara Division, Dhubri, and page number 33 is the certificate given by the Gauhati of Gauhati BO. No, XGDSMD Gauhati BO. And in view of the said RTI reply and the certificate, the respondent herein has refused to accept the notice and in that view of the matter, the findings so recorded by the learned trial court in paragraph number 19 that the summon was not duly served upon the defendant and thereafter setting aside the ex parte decree on payment of cost of rupees 4,000 is arbitrary and illegal, and the same requires interference of this court. The submission of Mr. Mitra needs further consideration. At this stage, notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Interim period of the petitioner will be considered on next date, returnable date.
24 is the date for next date. So interim till the returnable date, the matter will stay, my lord. That interim period is there. Because if they are otherwise, so if the
When the next date is fixed?
24th April for evidence. Till the returnable date, matter will.
Considering the submission of Mr. Mitra, learned counsel for the petitioner, and also considering the facts and circumstances on the record, till returnable date, the impugned order dated 3/1/2026, as in Mijje case number 6 of 2025, state.
Number 4.
Lordship, 4, 5, and 6 arises of the same suit, Lordship. So I filed 3 applications and all the 3 has been rejected. That's why it's separate because the miscase was registered as a separate miscase, Lordship. But my Lordship, the respondent filed a suit, money suit claiming refund of 60 lakhs, Lordship, saying that I entered into an oral agreement to sell my land. They paid the amount and having not executed their paid for execution of the sale deed or in refund of the money. My case was that I have paid back the money and which has been acknowledged, Lordship will find they have sent me a through my WhatsApp and email. That is at page 27. It has been notarized, Lordship. They acknowledge that they have received back. So I prayed for production of this document, Lordship, or referring my mobile handset to expert opinion, scientific expert analysis, whether I have received. Thus has been rejected. Now, Lordship, this is a vital document. It ought to have been considered, Lordship. That's section 30 of the CPC, Lordship.
No, no. This undertaking is,
They sent me in my mobile,
you have exhibited it before the trial court?
Lordship.
You have exhibited this?
No, I can
office?
exhibit it because it is a part of my it is part of my pleading, part of a annexure, but the original is with them, Lordship. Only. So
No,
unless they
while taking a printout of this undertaking
Lordship,
from your WhatsApp, whether you have obtained that certificate
no, that is not me.
65B?
No, Lordship. That's why I filed a petition that be my mobile handset be analyzed by a expert, or they let them produce this, whether they have it or not, have sent it or not. Lordship, in this section, under section
No,
30,
this document can be approved by the person who has written the same. This was notarized also.
notarized, Lordship.
You can examine the notary public.
Lordship, they are from
As-
Rajasthan. They are from Rajasthan, Lordship. Not from here. Lordship, it is notarized by Ajmer, Lordship. The plaintiff is from Rajasthan. That's the difficulty, Lordship. Otherwise, it could have been done.
Let notice go at this instance.
Lordship.
That what is this? The proceeding is pending.
My evidence has been, I have been cross-examination on DW1 has been completed. I want to adduce 2 more. And that has also been, that prayer has also been rejected. Listed witness. That has also been rejected.
You come to this CRP number 117.
17, Lordship.
117.
117. 117, Lordship, is production of document, Lordship. And next one is, Lordship, I pray for evidence of 2 witnesses. And the third one is production of that document, particular that undertaking, Lordship. Lordship may pass common order in all the 3 cases.
No, the orders are different in
Orders,
part, Mr. Chakraborty learned.
date is same, Lordship.
Petition.
6/125, Lordship. 6/126.
Restriction under Article 227 of the Constitution of India. The petitioner has challenged the order dated 6/1/2026 filed by the petitioner. Under Order 16, Rule 6 and 7, read with Section 151 of the Code of Civil Procedure. In money suit number 20 of 2019, seeking a direction upon the plaintiff and its partner to produce the original undertaking, struck advance receipt dated 18/1/2019, within bracket annexure 1, 2, and 3, and to have the same taken into consideration while deciding the suit. Mr. Chakraborty, learned counsel for the petitioner, submits that The petitioner is the defendant.
Defendant Lordship.
Defendant in money suit number
20 of
20 of 2019. And the said suit is pending at the stage of evidence of DW. And while the case was pending for evidence of DW, the petitioner has filed one petition number 766 of 2025 for production of original undertaking stroke advance receipt dated 18/1/2019. But by the impugn order dated 6/1/2026, the learned trial court has dismissed the said petition on the ground that permitting such an application at that stage without showing any compelling necessity would only delay the proceeding and disturb the orderly progress of the suit. And according to him, the findings so recorded by the learned trial court is illegal and arbitrary, and under such circumstances, he is contented to allow this petition. The submission of Mr. Chakraborty, learned counsel for the petitioner, needs further consideration. That is this notice be issued to the respondent, returnable in 4 weeks, step by speed post and also by usual process within a week from today. List after 4 weeks. Is there any interim pair here?
Lordship. Page 11, Lordship.
Considering the submission of Mr. Chakraborty, learned counsel for the petitioner, and also considering the facts and circumstances on the record, further proceeding of money suit number 20 of 2019 stands state till returnable that list after 4 weeks.
Deeply obliged, Lordship. Only in other cases, the missed case number will be different, Lordship.
Order this case number 2 different or date.
Deeply obliged.
7.
May I please? Lordship, present case has been filed by the petitioner arising out of one police case, accidental case, Lordship, registered 11/17 before the Haplong police station, Lordship. Accordingly, one claim compensation claim petition has been filed by the petitioner, Your Lordship. Annexer B, page number 20. The petitioner husband died in a road accident, Lordship, while during the course of his employment, Your Lordship.
No, at what is this? That application is pending now.
Your Lordship, this application is pending since 2018, Lordship. Only because of that, Your Lordship, the
2000?
2018, Your Lordship. Last 8 years, Your Lordship. Only because
At
of
what
that,
stage it is pending?
Lordship, for argument is this, Lordship. But Lordship, very surprisingly, Lordship, last 6 months, Lordship, last more than 6 months, Lordship, almost 7 months, Lordship, no order has been passed by this learned commissioner, Lordship. Only because of that, Lordship, the learned commissioner is not present there. In the event, no official staff is there, Lordship. But evidence has been submitted, cross-examine has been done, but subsequent stage, the insurance, that is the opposite party number 2, has filed a petition for granting opportunity to produce DW. Several more than 1 year, they have filed application and checking time. But subsequent stage,
Now, what is your pair in this petition?
my prayer is that, Lordship, please be direct the authority concerned to dispose of the present petition, Lordship, within a stipulated period as claimed by the statute 25A, the Employee Compensation Act 1923, Lordship.
Madam, you are appearing for?
Respondent number 2.
National Insurance Company.
Additional Deputy Commissioner. Additional Deputy Commissioner. For state.
Okay.
The Employee Compensation Act, Section 25A, clarified that. May I please to read, your lordship? Time limit for disposal of cases relating to compensation. The commissioner shall dispose of the matter relating to compensation under this act within a period of 3 months from the date of reference and intimate the decision in respect thereof within a period of the.
Why, Mr. Bora, why, Saikia, why this respondent number 2, additional deputy commissioner is right in this petition? Is he holding the search?
Yes, your lord. Respondent number 2, that is the additional district commissioner,
Yes.
as because there is a jurisdiction wherein the accident caused, lordship. So as per the compliance section, lordship, we have to intimate it to the additional district commissioner or the district commissioner of the concerned district. Therefore, in this petition, lordship, we implemented here as party respondent number 2, your lordship.
No, the search of commissioner, the commissioner is different from the ADC.
But lordship, as per Annexure C, lordship, page number 40, can you be please? Page number 40, lordship. So in regards to the accident, lordship, we intimated to the additional district commissioner Haflong, intimating him that we have filed the present claim petition in this jurisdiction, lordship, at Gauhati. Therefore, lordship, as per compliance section 21 of Employee Compensation Act.
The commissioner, workman commissioner, you have filed the case before the commissioner, workman, Kamrup M.
Yes, your lordship. Commissioner Kamrup M. Metro. Yeah. At this stage, not lordship, I am not pressing this case for merit, lordship, but only for compliance the statutory provision. Please be direct the commissioner, lordship, to dispose of the present, to dispose of this case, lordship, within stipulated period. That is my only humble prayer. Even since 5/6/2025, lordship, no effective order has been passed as on today,
Let
lordship.
notice go at this stage. We will call for the scan copy of the record. We will
Absolutely.
examine and see.
Your lordship.
Heard Mr. M. Soikia, learned counsel for the petition, and Ms.
M. Kalida.
Learned counsel for the respondent number 2.
Respondent.
In this petition under Article 27 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, the petitioner has applied for issuing direction to the respondent number 1, the commissioner. Under workman compensation, Kamrup M. Gauhati, to dispose of the WC case number 35 of 2018 within the prescribed period of 3 months under Section 25A of the Employees Compensation Act 1923. Where is the petition and the documents placed on record? Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 2, since Ms. Kolita entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Step upon rest of the respondent be taken by speed post and also by usual process within a week from today. Registrar shall call for the scanned copy of the record of WC case number 35 of 2018 from the Commissioner Workman. Urgently and list the matter after 4 weeks.
Your Lordship.
Item number 8.
Mate,
Mm.
here in this case, my lord, we have raised a file and a petition with a learned additional district judge Tinsukia, raising a question that whether the present petitioners are land grabbers within the ambit of my lord the Land Grabbing Act. Because my lord, I have submitted a document where the petitioner, present respondents, predecessor in interest, and our predecessor in interest are co-sharer. Patta has been issued in favor of both the persons, my lord. Accordingly, without having partition of the suit land, whether we can be whole as the land grabbers. That issue has been raised before the learned additional district judge by petition number 116. My lord, impugn order has been passed basically on the ground that that can be decided only after going to the trial. This is my case, my lord. Now, Lordship may take note of the first the impugn order, my lord. Basically, Lordship may take note of the first petition filed by the present respondents under Land Grabbing Act, my lord. Page 34, my lord. The facts in nutshell is such, here in this my lord, case, my lord. So far, the present respondent has raised before the Land Additional District Judge that their predecessor in interest have acquired a right title interest over 5 acres something land, my lord, out of which the present suit land 1 acre something, my lord, that has been forcefully occupied by us. That has been grabbed by us. Accordingly, action has been paid for to take action, necessary action in under the Land Grabbing Act, my lord. That is the, my lord, allegation raised in this case, my lord. Against that, we have filed objection, written objection, and in that case, my lord, we have specifically stated that no, we are also the co-sharer of the said land, suit land. Prior to that, my lord, what happened, my lord, in this case, injunction was also, administrative injunction was also granted. That has been, my lord, interfered by this honorable court, and we are directed to appear before the learned court below. Accordingly, we appear, and thereafter, my lord, the entire misdeed case has been disposed of, directing all both the parties to maintain status quo. That is still in force, my lord. Now, while we have appeared before the learned trial court below, my lord, we filed this petition. That is, my lord, page, my lord, 83, my lord. Annexure 5. This is the petition which we have filed regarding maintainability of the case, my lord.
Okay, Mr. Sharma, let notice go.
My lord, and this is what happened, my lord. I am the co-sharer.
Mm.
Lordship may take note of the page number, my lord, 87, my lord.
Mm.
Sorry,
Let the other
140,
side appear.
140, my lord. 140. This is the in vernacular, and in my lord, annexure 13, 138 is the, my lord, in translated version, my lord. Let me page 140, my lord. Page 140 may kindly note. 140. Patta has been issued in the name of Uday Narayan Hazam, Ram Narayan Hazam, and Uma Shankar Hazam. The predecessor in interest of the present respondents are Uday Narayan Hazam and Ram Narayan Hazam. And we are, my lord, successors of Uma Shankar Hazam. So we are co-sharers, my lord, and co-partners. Accordingly, my lord, so far the land is concerned, unless and until it is decided by the competent civil court as regards to the partition as well as the right to the interest and the proportionate share, we cannot be, my lord, whole as a land grabber, my lord.
Okay.
This is the main question, my lord.
Heard Mr. Sharma, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 21st of February 2026 passed by the learned additional district judge Tinsukia in petition number 1611 of 2024 filed by the present petitioner. In land grabbing case number 12 of 2024. It is to be noted here that by petition number 1611 of 2024, the petitioner herein has challenged the maintainability of the land grabbing case number 12 of 2024, but the learned tribunal has dismissed the said petition on preliminary issue, land grabbing case on preliminary issue and rejected the said petition. Mr. Sharma, learned counsel for the petitioner, submits that the petitioners are the co-sharer of the disputed land and the said land has not been partitioned between the petitioner and the respondents, and the petitioner have their right over the said over the disputed plot of land, and in that view of the matter, the land grabbing case number 12 of 2024 is not maintainable, and though the petition was filed, petition number 1611 of 2024 was filed challenging the maintainability of the land grabbing case, and to frame one preliminary issue on that point, the learned learned tribunal has dismissed the same. And since the present petitioners have also right title and interest over the disputed plot of land, the dismissal of the petition by the learned tribunal is illegal and arbitrary, and on that count, Mr. Sharma has contended to interfere with the same. The submission of Mr. Sharma needs further consideration. At this stage, notice be issued to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Is there any interim pair?
Yes, my lord. Further proceeding may be otherwise, my lord. It is at the stage of
And
evidence.
considering the submission of Mr. Sharma, learned counsel for the petitioner, and considering the fact that the case is pending at the stage of
Evidence.
evidence,
Speed of
stage of evidence, and further proceeding with the case will cause prejudice to the present petitioners. Further proceeding of the land grabbing case number 12 of 2024 stands stayed till returnable date, list of the 4 weeks.
Alia, my lord.
Period, your lordship. Lordship, the other day, my lord have asked me to clarify, my lord, confirm whether the steps have been taken by the decree holder, my lord, with regards to issuance of the writ, my lord. As per my instruction, the steps have not been taken, my lord, by the decree holder. But the thing is that, my lord,
The
the next day,
petition is still pending.
yeah, the petition is pending, my lord.
So only after disposal of that petition, the court will proceed to the next stage.
But, my lord, as of now, my lord, the next date is fixed on 17, my lord, for filing their objection and objection hearing, my lord,
In the petition.
against my petition, my lord. So my
Mm.
only anxiety is, my lord, in between this, my lord, there is no order for recall or stay, my lord, of that particular writ, my lord. So in between, my lord,
Maybe till disposal of the petition, definitely the court will not proceed to the next stage.
so my lord, I was paying for that
No,
limited interim. my lord.
let notice go at this stage.
My lord.
Let notice go at this stage.
Okay, my lord, but at
And
least,
if in the meantime the petition is disposed of and the court proceeds to the next stage, then you can mention this matter. We will take a call.
but that was my only anxiety, my lord. Because
You can mention the matter.
my lord, at least a short date may be fixed after vacation, my lord.
Okay.
So I'll take steps and the interim may be considered on the next day, my lord.
Heard Mr. Deca, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has tried for issuing direction to the petitioner has challenged the order dated 16/10/2025 in past and title execution case number 12 of 2013. The learned counsel for the Mr. Deca, learned counsel for the petitioner submits that the predecessor of the respondent herein had instituted one title suit, being title suit number 45 of 1978, claiming right title and interest over a parcel of land measuring 1 Katha 5 Lesa, situated at Golpar. The said suit was initially decreed by the learned trial court. Thereafter, the defendant has preferred one appeal, being title appeal number 85 of 1986, before the learned district judge Golpara. And the said appeal was disposed of by order dated 28/8/1988 and remanded the suit with a direction to carry out survey of the suit land. The said order of remand was challenged before this court in second appeal number 37 of 1989. But the same was dismissed by the order dated 6/1/1997. Thereafter, on receipt of survey report, the learned trial court has decreed the suit by the judgment and decree dated 27/11/2001. And the said decree, judgment and decree attain finality. And thereafter, the decree holder has initiated execution proceeding by instituting title execution case number 12 of 2013 before the Court of Learned Civil Judge Junior Division number 2 Golpara. And during the execution proceeding, an application was filed raising the objection of executability on the ground that the original defendant, namely Abdul Hai, suffered demise on 25th of June 2000 prior to passing of the judgment and decree dated 27/11/2001. Thereafter, the learned executing court has accepted the objection by holding that the decree was a nullity and not executable. Then, the said order was challenged in Civil Revision Petition number 132 of 2022 before this court, and the same was disposed of by order dated 19/5/2025 by holding that although Abdul Hai suffered demise prior to the decree, his estate was duly represented through his wife, who was already on record during the suit, and therefore the decree could not be treated as a nullity solely on account of his death. Thereafter, on 30th/6/2025, the decree holder filed a petition, being petition number 545 of 2025, seeking a declaration that the execution proceeding would proceed against the legal heirs of late Abdul Hai. And the same was listed before the court on 16/10/2025. But without notice being served upon the respondent, the learned executing court, by order dated 16/10/2025, hold that execution proceeding would proceed against the legal heirs of Abdul Hai, including the present petitioners, and being aggrieved, the petitioner approached this court by filing the present petition. Mr. Deka further submits that the learned executing court by the impugn order dated 16/10/2025 has issued writ for delivery of possession. And when the petition was filed,
My petition, my lord, on 19/1/26,
where is that petition?
page 65, annexure 9.
Deka also submits that thereafter the petitioner herein has filed also submits that the petitioner herein has also filed one petition under section 47 read with order 27 rule 18A of the Code of Civil Procedure, and the said application is pending, and the next date is fixed on
17/4.
17
17/4.
17/4/2026, and by order dated full stop. It is to be noted here that by order dated 6/4/2026, Mr. Deka was directed to obtain instruction as to whether any writ has been issued by the learned executing court pursuant to the order dated pursuant to the impugn order dated 16/10/2025. And today, Mr. Deka, on instruction, submits that the writ has not yet been issued. However, the matter is fixed on 17/4/2026 for disposal of the for hearing on the petition.
Yes, ma'am.
Hearing on the petition under order 47, no, under section 47, read with order 27, rule 18A. Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks. Returnable on Can you serve notice by dusty mode? Can you serve notice by dusty mode?
My lord, no.
So we will fix the matter in the last part of this month. Correct. 29. 29. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. No, list on 29. List on 29. Interim period of the petitioner will be considered on next.
Okay.
Item 33.
Well, this is a revision petition under 115. Basically, my lord, this is an order. This is impugn, my lord. This is on passed on 10 to 2026. The annexer 8 is, it is page, my lord, 38 from 125, my lord. And by this, my lord, the facts of the case is this, my lord, the petitioner, my lord, and the respondent. Fortunately, they were, my lord, co-owners. And the respondents, my lord, one property was there in Jorhat. So that property is an ancestral property. That was, my lord, let out to the petitioner for purpose of a guest house and, my lord, marriage home. So during the, my lord, tendency, the continuation of the tenancy, that was initially commenced in 2019, that is on 29/6/2019. And again, that was a second, my lord, that was extended by another deed, my lord, 24/12/2021. And that was continued, my lord, for another 11 months till October 31st, 2022. And after that also, my lord, the payment, whenever I going to tender the payment of the rent, he refused. On refusal, my lord, I was regularly paying the rent in the court. But during that time also, my lord, prior to institution of this suit, another, my lord, treating, my lord, was coming from the respondent. So on that issue, the plaintiff has instituted a title suit number 40 of 2022, with a, my lord, Miss J case under order 29 rule 1 and 2, my lord, 39 rule 1 and 2. And that matter was, my lord, pending before the court, and that in that case, the respondent has contested the case by filing his written statement as well as a counterclaim for eviction of the tenant. So by this time, my lord, when this continuation of the tenancy and when I paying the rent, unfortunately, my lord, on 25/4/2023, my lord, forcefully I have been evicted from this premises. My lord, all belongings, the total number 122 items, my lord, I listed before this trial court. So all ACs, my lord, all my lord, this bed and, my lord, my lord, geysers, all, my lord, whatever is required in for running a guest house, all are inside, including one scooty also. So on that, my lord, the learned, my lord, the first, my lord, trial court, it is on my application, taking on application the 3912. The case was filed under section 6 of the specific relief act, my lord, for recovery of deposition and other, my lord, consequential relief. And but, my lord, when the case was taken by the trial court was very much, my lord, satisfied with the all grounds taken by me as well as by the respondent, and came to the conclusion that the three principle, golden principle toward granting temporary injunction, all are in my favor. But
No, that's right. Now you tell me whether the impugn order passed by the learned civil judge,
civil judge senior division.
senior division, dated 10th of February
Yes, my lord.
2025, suffers from any illegality or infirmity?
Yes, my lord, definitely, my lord.
How?
My lord, because the findings of the trial court, that was a, my lord, prima facie, that was a dispute exists because they are trying to evict it in reference to the, my lord, earlier title suit, that is in 40 of 2022, still pending, and where he filed the counterclaim. And second, my lord, there is a, my lord, dispute that I have paying the rent and my guest house also running it with my all effort, all belongings inside the house, and entire campus has been, my lord, covered by some tin covering with some tin. My lord, the entire cover has been, ingress and egress has been completely closed. On that issue, my lord, the trial court came to the conclusion that prima facie as well as balance of convenience, all in my favor. So accordingly, my lord, the injunction was granted. And this is, my lord, the things is that the unless and until the legal procedure is instituted by the respondent to evict me, the forceful eviction cannot be, my lord, allowed by it is, my lord, established law. The Supreme Court all the time and again always, my lord, decided these things in favor of the tenant, my lord. So if I have to be evicted, they have to institute a proceeding as per the law. That is not been initiated. Only by forcing by using the force, eviction cannot be, well accepted. On that issue, my lord, the trial court has prima facie established my case in my favor. Now, lordship will come, the page number 136. This is the, well, no, before that, my lord, 135, my lord. How, my lord, no, my lord, any basic well, discussion on the whatever stand taken by the respondent and by the plaintiff, only some surmise and some probability has tried to dispose of the entire matter and by negated my right. So kindly see the page number 135. Para number 12, my lord. How it has been, my lord, decided. Lordship got it, my lord.
Mm.
Well, 12, it is seen that the on superannuation from the service, the opposite party number wanted to suit property for his residential purposes. Accordingly, he has taken building permission from the concerned authority and the same was intimated to the petitioner respondent. On the other hand, trade license in the name of the petitioner respondent for running the business in the suit premises is not also not in force due to non-renewal. The petitioner respondent has not paying the rent since the time of the possession. That's the same by the applicant. The fact lead to the belief that the opposite party is plea of the voluntary vacating the premises by the opposite party by the respondent petitioner rather than the fact of forceful disposition of the minor respondent. This is, my lord, only the belief, my lord. This is not only basis of fact. The Azahar and the police report is everything is showing in my favor. And second, my lord, lordship come to page para number 13. Again, the act of the obtaining the building permission and the superannuation of the appellant's appellant opposite party shows his bona fide requirement of the suit premises. As such, I am of the opinion that it is not the petitioner respondent who is claiming the suit property for free. It is also a wrong finding, my lord. I am regularly paying my rent till the date of my eviction. Then, my lord, but opposite party who has prima facie case of the present situation. The learned, my lord, this is again, my lord, lordship come to the page number 138, para number 19. All these three decisions, my lord, decision has been decided, all are in the favor of the, my lord, the plaintiff, because it is wrong, my lord, earlier decision that ownership, my lord, I am not disputing the ownership. This is the ownership dispute whenever it says I cannot claim my right title interest against the true owner. This is a different thing. And the tenancy is a different thing, my lord. Tenancy is not required to be against the, my lord, actual owner. Who has, my lord, I have tendered it, my lord, tenant, my lord, the rent, and who has received the rent, he is that owner.
So you have already been evicted from the suit
Yes,
premises.
sir, I have been forcefully evicted. That cannot be done. So this is my case, sir. That is why I came before this court under section 6 of the Special Relief Act within 6 months, not only 6 months, within the next day. So, my lord, these things, whenever it is decided by the trial court, entirely in favor of me. And now it is admitted fact also here, lordship will find in the impugn order that my all belongings are still inside the premises. So there is every possibility that can be, well, destroyed and that any character of the land and disputed property can be changed. And whatever is I have invested, that can go in, my lord, vain. Nothing will happen.
Mr. Monto, you see the observation made by the appellate court
Yes, my lord.
in paragraph number 12
Yes, my lord.
that the trade license in the name of the petitioner stroke respondent for running his business in the suit premises is also not in force due to non-renewal. The
But-
petitioner respondent has
Yes, my lord.
not been paying rent since
Yes.
the time of possessing the same
Yes, my lord. That is
by
I
the
lordship,
appellant.
then I lordship will come to the page number, my lord. This has been page number. It is started from, my lord. It is 38, my lord. It is totally false, my lord. It is contrary to the findings of the trial court. And so far the license renewal is concerned, this is not a matter to be decided in the, my lord, this tenancy agreement, my lord. Kindly see, my lord, page number 38. From 38 onwards, all other rent receipt I have paid, I have deposited in the court by our miss case. At the last, my lord, the page that has been 49.
Okay, let notice go at this is this.
My lord,
Let notice go at this.
my lord, the stay is required, my lord, because no, my lord, kindly see. Now, kindly before lordship, my lord, kindly come to page number 49. Page number 49.
Page number?
Page number 49.
Yes.
This is my lord land, my lord paying receipt to the deposit in the court for the month of my lord April. Kindly see, my lord. Entire month of April I have deposited. So during the time of my forceful eviction, I was the bona fide, my lord, occupying the premises by paying a tenant, my lord, the rent in the court. So court, my lord, the appellate court hold that I was, my lord, not paying the rent. It is, my lord, the purpose finding. This is clearly, my lord, written, my lord, for the month of April. So my April period, my lord, 30 is continuing. So I was evicted on 25th. So before expiry of my that rent also. And the specific, my lord, section 66 of the specific relief act, it specifically required that if the person is, my lord, disposes forcefully, illegally within the 6 months, my lord, I have come, that is the, my lord, duty of the court to restore me to the, my lord, the actual position. It is not a matter of who is the owner, who is not the owner. It is not to be decided. Only, my lord, possession and disposition is to be considered. So on this very day, it is very much, my lord, accepted by the trial court that I was wrongfully disposed. That is why, my lord, the interim order was granted, but the appellate court knows, my lord, basic any reason was given. It is simply saying the probability, probable, and everything is there. No detailed
Mr.
discuss,
Mohanto, you say, what is the standard of proof in civil suits,
my lord.
in civil cases?
Civil court, yes, my lord, all the, my lord, the direct evidence and whatever there, well, that to be proved there directly. So in this case, my lord, I have whatever I required, my lord, I have proved everything.
Let notice go at this.
No, my lord, kindly see the whenever, no, my lord, this civil
Sorry,
suit
sorry.
and tenancy case is a totally different, my lord.
Maybe.
Tenant, my lord, unless and until, my lord, I am a defaulter and bona fide ground is proved, then I cannot be
Let
evicted.
the
And that
other
no,
side
my lord.
appear, we will
No, my lord, I have to
consider.
refer to one decision, my lord.
Maybe.
The Supreme Court decision is there, my lord. It is, my lord, specifically stated. Yes.
You say you are not in possession now. You have
No,
already
this is
been
not to be
evicted
decided,
from
my
the
lord.
premises.
Decision needs to be decided that on the day of, my lord, eviction, whether I was in my possession, whether I was a tenant or paying the regularly rent, my lord. This is to be decided. This is other suit and tenant suit are
Okay.
completely different.
That will be decided definitely.
So this is the matter of fact.
After hearing the
Right.
party.
But the initially, my lord,
Please.
my lord,
Heard, Mr. Mount.
my lord, kindly see the decision, my lord. I rewrite one
You
decision.
submit it to the court.
My lord. But here are the same
This
case,
petition under
in
article
similar circumstances.
224
By the landlord and tenant relation
under
was there.
section 115 of the Code of Civil Procedure. The petitioner has challenged the judgment and order dated 10/2/2025 passed by the learned civil judge senior division Jorhat in Miss Appeal number 6 of 2024. Is to be noted here that by impugned judgment and order dated 10/2/2026, the learned civil judge senior division Jorhat has set aside the order dated 14/11/2024 passed by the learned civil judge junior division number 2 Jorhat in Measure case number 26 of 2023 arising out of title suit number 39 of 2023 and thereby vacated the injunction order restraining the opposite party stroke appellant, his relative, agents, etc. from demolishing the suit premises, making any construction over the same, transferring the suit premises to anybody else by way of sale, mortgage, lease, letting out, etc. till disposal of the main suit.
In that case, my lord, it is similar to me. In that case, my lord, the petitioner, he was a tenant. They on, my lord, they bequeathed the property by way of a will. My lord, his tenancy was denied and he was tried to be evicted. So on the ground that he was defaulted and other things, my lord, the learned, my lord, appellate court, the trial court, my lord, given the judgment against the trial with this plaintiff. Then, my lord, on gone to ultimate, my lord, SLP. SLP, my lord, the direction was given that they, until, my lord, he has been lawfully, my lord, evicted, he may be allowed to stay on payment of the rent. But this is the things, my lord, all the principle, the whole the field all the time, my lord. This is many judgments are there. Supreme Court and time and again always saying that without following the proper procedure of law of eviction, no person can be evicted forcefully. But this is the case of my also. That is a soft room, my lord, in that case. I'm sorry, sir.
Where's the petition and the documents
My lord.
on record?
My lord, kindly I want to refer.
Mr. Monta, please don't disturb while I am dictating the order.
No, I am sorry, my lord. I am sorry, my lord.
Please sit down.
My lord.
Maintain the decorum of the court.
I am sorry, my
You were a
lord.
senior fellow.
My lord, I am sorry, my lord. Just I want to, my lord, refer to, my lord, specific provisions, ready back to section 6. only, my
Let
lord.
notice be issued to the respondents, returnable in 4 weeks. Step be taken by speed force and also by using forces which may be from today. Though the learned counsel for the petitioner has applied for staying the impugned order, so passed by the learned civil judge, senior division Zorat, yet in view of the observation made by the learned civil judge senior division in the impugned order, especially at paragraph number 12 and 13, this court is not inclined to consider the interim fair at this stage. However, the court will consider the same on next returnable date on appearance of the other parties, list of weeks.
My lord, the status quo as on my lord, at
Sorry.
least my lord, otherwise my lord, my property, my lord,
Sorry.
entire property will be changed and my,
Back
I'll be irreparably my lord, suffer loss, my lord.
Item number 17. May I please, Your Honor? As per official data 2426, the service report on respond number 1 and 2.2 not received, Lord. And we are allowed to take fresh step because notice were issued long ago in the year 2024.
Whether you have taken a step,
Yes, taken steps, but neither AD card nor answer notice are returned back. As per-
when did you take a step?
take steps in the year 24 when notice were issued.
24.
I maybe take
In 25, you have not taken any step.
25, not directed.
Not directed. Whether the case was listed in the year 2025, not listed.
Not listed. Lord.
Pardon, Mr. Your name, please.
A Burwa,
Learned counsel for the appellant,
applicant. Lord.
struck applicant. Office note.
2426.
Dated 2/4/2026 indicates that neither AD card nor answer notice received from the respondent number 1 and 2 by the section till date. The learned counsel for the applicant submits that he may be allowed to take fresh step upon the said respondents. No, said respondents. Fair allowed for step be taken by speed post and also by usual process within a return to the list of the products.
Parts of it. Item 18.
May I please, Your Lordship? The service is complete, Lordship. Matter will come for admission, Lordship. Lordship, they were supposed to file, already filed, haven't been filed, cost of administration. Again.
Heard Mr.
Be the ruler.
Learned counsel for the petitioner and also heard Mr. C. Sharma, learned counsel for the respondent. Mr. Devri submits that in this matter, service has been completed and the matter may be listed for admission. Accordingly, it is provided that rest is a list the matter for admission hearing after vacation.
Also, they are the interim. Interim. they are
Interim
the-
order passed earlier shall continue.
Due.
Item 19.
None appears for the applicant on call. List the matter after. No, none appears for the applicant on call. Order dated 11/2/2026 indicates that on that day also, the applicant remain unrepresented. In that view of the matter, this application stands dismissed for non-prosecution.
Items for admission. Item numbers 9 and 10.
Milord, and pray, Milord, item number 10 petition may be taken up first, Milord. CRP IO Milord 470/2025. Before taking to the merit of the case, Milord, Lordship, here in this case only one issue involved, Milord, where the principal defendant, Milord, and the present respondent plaintiff filed title suit, Milord, 7/2020, Milord. In the written statement, Milord, as well as one application under section 11 of Res Judicata, we have made application, Milord, that
so far as duct number 135 and 147 is concerned, my lord, already, my lord, decided on this point up to till this honorable court, my lord, and plaintiff failed before this honorable court, my lord, in second appellate stage, my lord. Then, my lord, on the same issue schedule 2, my lord, again filed this present title suit. So, my lord, the plaintiff kindly have a look, page 13, annexure 1. And I like to take you directly, lordship, the prayer, page 22, paragraph 17, page 22 and 23. Lordship will find page 22. I'm concerned, my lord, schedule 2. For the decreeing exclusive right, interest, and confirmation of possession of the plaintiffs over the land described in schedule 1 and 2 below, number B, my lord. For a declaration that principal defendant 1 have no right, title, interest, even possession over the land described in schedule 2 below, number 3, my lord. For recovery of khas possession in the event of dispossession during the pendency of the suit over the land described in schedule 2 below. And finally, my lord, D, my lord, the injunction on so far as schedule 2 concerned. What is schedule 2 now, my lord? At next page, my lord. Page 23, my lord, schedule 1. Schedule 1, in second arrest patta number, various ducts numbers there. I am concerned only, my lord, duct number 135 and 147. Kindly, my lord, mark it, my lord. 135 and 147 duct number. That is the schedule 2, my lord, here. And schedule 2, lordship will find the piece of parcel of total pedian measuring 4 kathas, that is second arrest patta 44, duct number 135 and 140. I'm on this point, my lord. I'm a question I'm raising so far as schedule 2 is concerned, my lord. Now, lordship will find I've filed an WS in this matter, my lord, and specifically I have taken in this matter at page 34 in my WS. Paragraph 22. A, B, C, D. In 22 AM, lordship, I raised the question. The instant suit is barred by res judicata as because the dispute in the suit has finally been settled by the Honorable Gauhati High Court. Number B, my lord, the plaintiff, along with other earlier filed title suit 90 of 1992 in the Court of Learned Civil Justice number 2, Kasar Silchar. In the suit, the plaintiff saw declaration of right, title, interest over the suit land along with the other relief. The said suit was decreed earlier in favor of the plaintiff and others who were the plaintiffs in the earlier suit. As against such judgment decree, answering defendant number 1 before the title appeal 5 of 1999, before the Honorable Court of District Judge Kasar Silchar, and the said appeal was heard in presence of the both the sides, and the appeal was allowed in contest with the cost setting aside the said decree of title suit censure. As against the said judgment passed by the learned District Judge Kasar, the present plaintiff and her 2 other sisters before RSA 65/2002 before the Honorable Gauhati High Court. After hearing both the sides, Honorable Gauhati High Court was pleased to dismiss the said appeal, and impugned decree was maintained by the Honorable Gauhati High Court. That is my case. Next, my lord, my application under section 11 at page 40, annexure 3. That is my petition number, my lord, 323 of 323/7. That is my application, my lord. Lordship will find very specifically I have taken paragraph 2, 3, and 4. 2, my lord. The father of the plaintiff, late Dutnath Singh, during his lifetime sold his share of land measuring so under duct number 135 and 147. That is part 2 to the defendant petitioner by registered sale deed dated 22/5/1987. This is important, my lord. 22/5/1987. Now, my lord, paragraph 3. That the father of the plaintiff later filed title suit 90 of 1992 against the defendant petitioner in the Court of Civil Justice number 1 for the cancellation of the said deed and for declaration that defendant did not acquire any right, title, and interest through the said deed. On the date of the Dutnath Singh, the plaintiff of the instant suit, Krishna Singh, and her 2 sisters, Bina Singh and Molina Singh, were made party in a title suit so. The title suit so 92 was ultimately decreed in favor of the plaintiff by the then Civil Justice number 2. Paragraph 4, my lord. The defendant petitioner preferred the title appeal so and as against the judgment decree so passed by the Civil Justice number 2. The learned District Judge Kasar allowed the appeal for defendant by the judgment that an order dated 5/12/2001 and thereby set aside the judgment of decree dated title suit number so dated 10/2/1999 passed by the Civil Justice number 2. that the plaintiff and her sisters before RSN number 65 2002 in the court Honorable Gauhati High Court and against the judgment of District Judge in Kasar Silchar Swecho and Honorable Gauhati High Court dismissed the said appeal preferred by the plaintiff and thereby decide. And finally, paragraph 5, my lord. The Honorable High Court finally decided the matter RSN number so in respect of the claim of the parties of the present suit over the suit land. The matter directly and substantially in issue in present suit has been directly and substantially in issue in the former suit between the parties. As such, the matter of the instant suit cannot be tried again by this honorable court. The parties and subject matter of the present suit is same as it was in title suit number 1992, finally decided by the High Court. So ultimately, I prayed for Milord decide this issue on 11. Now, Milord, that plaint of the 1992 at page 66 and at chart 10.
Page number 60,
Lordship,
page number
page 66, Milord.
66.
The father of the plaintiff, Milord. And when he died, then that plaintiff entered in the matter. That is 90 of 1992,
So
Milord.
where is the schedule of this
Yes, Milord.
page number?
Yes, Milord. Page number, Lordship, like page 72 first, 72 and 73. 72, Milord. Sorry, Milord. 71 prayer, first prayer. The regarding declaration
No,
of
no,
that.
the schedule of the land.
Yes, schedule of the land, Lordship will find page 73.
Hmm.
Duct number 135, 147.
Schedule 2.
Schedule 2. Duct number 135, 147, and second arrest part number 41. This is Milord. I'm concerned only that duct number, the two duct number, 135 and 147, not other duct numbers, Milord. Then, Milord, Honorable High Court's judgment, Milord, I have enclosed in my
No,
item
no.
number.
This schedule is in RSN number.
Milord, present, Milord,
This
7 of 2020, title suit. Our RSN number, Milord, RSN number, Lordship will find 65 of 2002.
yes.
But Your Lordship, this is in the instant case, Milord, that document RSA order I could not enclose, Milord. In so far as item number 9, I have enclosed RSA. Lordship, kindly, Milord, this is RSA. I have also enclosed this RSA order at item number 9. Very first, Milord. Please. This second appeal has arisen out of judgment and decree dated 5/10/2001 appellate passed by Learned District Judge Kasar Silchar in title appeal 599, setting aside and reversing the judgment and decree dated 10/2/99 passed by the Learned Civil Judge Senior number 2 in Silchar title suit number 1992, whereby the Learned Trial Court had decreed the suit in favor of plaintiff. Ultimately decided this issue, Milord, and finally observation made by this honorable court at paragraph 10, para 10, Milord. That so far as that Kabbalah 1987 is concerned is not disturbed, Milord. Appellate court findings appreciated. And paragraph 10 it says that in the result, for reason discussion about this appeal fails, impugn decrease maintained. The appellate court decrease is maintained. That means so far as 135 and 147 already answered. Whether they have preferred any SLP before the apex court, I don't know. I don't have any idea. Since that they have not taken. Since that means the findings on so far as duct number 135, 147 is the finality of this from this order, Milord. Now, Milord, the impugn order lawsuit will find at page 48. Before taking the impugn order, Milord, they have filed objection on my section 11 petition, Lordship. Their objection at page 43. Only one paragraph I will read from their objection. Annexure 4, page 43, and operative portion of the objection, page 46. D. Absolutely relying only paragraph D, the impugn order, without going through the records, paragraph D. That moreover the subject matter, title suit 90 of 1990.
Page number?
Page number 46, Milord. their objection D.
Hmm.
That moreover, the subject matter of title suit of 1992 was for cancellation of the sale deed, particularly doc number 135 and 147, my lord. In suit patta and present suit 720 for declaration of right title, interest, and confirmation of possession of doc number 135. But here, my lord, in the plain it is there is a 147, but they have not mentioned 147 here, my lord. Kindly, my lord, this is very important. Learned trial code also not written that 147. 135 and the subject matter issue of the both the suit are different and parties are also different. Very interesting, Melo. They claim the parties are also different. As such, the under section 11 CPC, the principal res judicata is not attracted, Melo. Since till second appellate court, Melo, they have approached, they are saying that parties are different, Melo. Now, Melo, impugn order lordship will find at the very next page, Melo, page 48. That is on 21/12/2023, my lord. Lordship, the front page, my lord, is the fact recorded, operative person, page 49, my lord. This is a fact recorded from both the sides, my lord. After going through from here, page 49, after going through the documents and hearing both the sides, it is seen that the instance is filed by the plaintiff for declaration of right title, interest, and confirmation of possession over the doc number 135. Also missing 147 here, my lord. Where is the plaintiff 147? Just because of the plaintiff has not mentioned 147, it is not there, my lord. So already plaintiff they recorded the 147 also. And that where is the title suit 1992 was filed by the plaintiff for cancellation of sale deed of doc number 135 and 147. Considering the subject matter and issue in both the suits are different, my lord, and parties are also different, my lord, and for which section 11 of the CPC is not attracted and applicable in the present suit, the instant suit is not barred by the principle of res judicata as a matter directly and substantially in issue in the present suit has not been directly and substantially issued title suit 1992 . My humble submission, my lord, while they're filing the title suit after on this honorable court on second appeal, not even single whisper made so far as second appeal decree is concerned. Absolutely silent on this point. Now, my lord, very interestingly, my lord, page 50, my lord. Page 50, my lord. That is a petition of 132 of 8, my lord. Present defendant number 1 made an application to call for records. To calling for records, my lord. What the records I sought, my lord. That means, my lord, at page 52. Schedule, item number 1. I sought, my lord, the entire records of title suit 1992. In schedule, my lord, page 52. Next record I saw at page 53, my lord, item number 2, that is entire record title appeal 5 of 1919, original, my lord. And finally, my lord, item number 3, enter records from the certificate issued by the assistant. These documents present defendant sought, my lord, to call for proper adjudication to get a just and fair trial, my lord. He sought his application. Ultimately, my prayer has also been rejected, my lord, relying on that impugn order, that is on 2023 order, at page 56 and excerpt 7, my lord. That is 11 to 2025, which is impugned in item number 9, my lord. It is also under challenge, my lord, in item number 9. The relevant portion I will read, my lord. These are all facts recorded at page 58. May I read, my lord? After hearing both the sides, the court has found no reasonable ground to call for the records from the Court of Learned Civil Judge Senior Division Kasar Silchar, as well Honorable District Judge Kasar Silchar, and from Honorable Gauhati High Court. I never sought any records from Honorable, wrongly recorded, my lord. And from the Lakhipur Revenue Circle, Bilal Kasar. Moreover, an order has already been passed by this court, vide dated 21/12/2023. That order, just I read, my lord. That the instant suit is not barred by the principle of res judicata, as the matter directly and substantially issued in that present suit has not been directly and substantially issued. The further calling for the records at this stage will cause unnecessary delay in the speedy disposal of the instant suit, and the period of petition hereby extend. Just because of, my lord, ground taken that it will take some time delay, so not call the records. Then I prefer review application before the same court at page 60 and excerpt 8, my lord. Review of this order, my lord. Page 60, Then my review application also rejected on the same ground, my lord. Page 65. Sorry, page 64. That is 1/2005. This is the final. These two impugned orders are I challenge in item number 9. And operative person, page 65, my lord. One paragraph only.
So,
Ultimately, my lord,
whether in the title suit number
and
90 of 1992,
yes, my lord.
and also in the title suit number,
Title suit of
7
7
of
of 2020, schedule 2, my lord.
the pairs are different.
My lord, prayers, my lord, kindly sue. In prayer instant title suit, page 22. Paragraph 1, A, B, C, D. All the 4 prayers covers my case, my lord. In first A, my lord, declaring exclusive right, interest, and confirmation of possession of the plaintiffs over the land described Schedule 1 and Schedule 2. Schedule 2, my case, my lord. Number B, my lord, for a declaration that principal defendant 1 have no right, title, interest, even possession over the land described Schedule 2, my lord, already answered this code. And number C, my lord, that for recovery of khas possession from the Schedule 2, my lord. That is 135, 140. And finally, my lord, they sought permanent injunction on Schedule 2, my lord. So that means whole title suit, my lord, whole case is on Schedule 2 based, my lord. Already Schedule 2, they failed. Before this court, my lord, they have no challenge before the apex court. My lord, this is on finality. How they can again on Schedule 135, 147 can file title suit, my lord? Already answered, already decreed in my favor, my lord. And therefore, my section 11 petition rejected. Then I made an application to call for record. Same is also not been considered just because of that. That earlier in 2023, this that trial court has said that it is not barred by res judicata. Thus, relying on that, court could have called the records to verify my records. After going through the record, if the court found it is not, sorry, my lord, not attract the section 11, then court could have take decision. But without going through a record, just because it will take some time, it will take delay, therefore not call for record. Is that the ground, my lord? And admittedly, my lord, that earlier impugned order 21/12/23 said that parties are different, suit are different. How, my lord, parties are different, suit are different? Said the doc number same, parties are same, my lord. How could get without going through a record? Plaintiff has wrongly stated, my lord, in paragraph D, just as it is paragraph D recorded, and my case was rejected, that it is not attract, not barred by section 11, my lord. And that is my case, my lord. And my lord, in the item number 10, my lord, I challenge that original order 21/12/2022, in so far as item number 9, that's rest to regarding rejection of my in the record calling order, that is under challenge in item number 9, my lord.
Okay.
Deeply obliged.
Okay. We'll resume after 5 minutes.
I do to place, my lord, regarding res judicata and regarding non-calling of records, my lord. My lord, Air 2000 Supreme Court 1238, that is paragraph, I am relying on paragraph 12 and 18. Section 11, issue is concerned. Paragraph 12 and 18. May I read, my lord?
Yes.
Yes, lordship, yes. 2, my lord, so 12. It will be noticed that the words used in section 11 CPC are directly and substantially in issue. If the matter was in issue directly and substantially in a prior litigation and decided against the party, then the decision would be res judicata in a subsequent proceeding. Judicial decisions have, however, held that if a matter was only collaterally and incidentally in issue and decided in an earlier proceeding, the finding herein would be not ordinarily be res judicata in the later proceeding where the matter is directly and substantially in issue. Now, para 18, my lord. In India, the Mullah has referred to similar case, Mullah 15 AD 104. The learned author says a matter in respect of which a relief is claimed in an earlier suit can be said to be generally a matter directly and substantially in issue. But it does not mean that if the matter is one in respect of which no relief is sought, it is not directly and substantially in issue. It may or may not be. It is possible that it was directly and substantially in issue, and it may also be possible that it was only collaterally and incidentally in issue, depending upon the facts of the case. The question arises as to what is the test for deciding into which category a case falls. One test is that if the issue was necessary to be decided for adjudicating on the principal issue and was decided, it would have to be treated as directly and substantially an issue. And if it is clear the judgment was in fact based upon the decision, then it would be res judicata in a latter case. Mulla Suencho. One has to examine the plaint and the written statement, the issues and the judgment to find out if the matter was directly and substantially an issue. Suencho. This is paragraph 18. Here, admittedly, my lord, in both the plaints, my lord, it directly and substantially an issue into former suits, my lord. Now, so far as my second citation is concerned, my lord, Air 2009 Supreme Court 2352. Here I frame paragraph 12, 13, and 15, my lord. Para 12, my lord. It is under order 13, rule 10. If bringing on record a document is essential for proving the case by a party, ordinarily the same should not be refused. The court's duty being to find out the truth, the procedural mechanics necessary to arrive at a just decision must be encouraged. We are not unmindful of the fact that the court in the said process would not encourage any fishing inquiry. It would also not assist a party to procuring a document which he should have himself filed. There cannot furthermore be any doubt that by calling for such documents, the court shall not bring about a situation whereby criminal proceeding would remain state, as it is a well-settled principle of law that where civil proceeding is also criminal proceeding is pending, the latter shall get primary. No, Lordship, I'm skipping the paragraph 13. Paragraph 15, my lord. Sorry. Oh, no. My lord, I'm sorry, in paragraph 13, my lord. Next, paragraph 14, my lord.
Yes.
In a civil suit, a document has to be proved. The report is of an expert is required to be brought on record in terms of the provision of the Indian Evidence Act in regard to the provisions contained in Order 13, Rule 8 of the Civil Court would furthermore be entitled to substitute the original document by certified copy. We therefore fail to appreciate as to why the said original document could not be called for. We may notice that the division bench of the Calcutta High Court in Union of India in another versus Suencho held that a document may also be called for from the authorities under the Income Tax Act, stating the further it may be pointed out that Order 13 Suencho Rule 10 CPC that does not refer to a judicial proceeding. It refers to a suit or proceeding. Even if the proceeding in connection with the issue of a charge warrant under the Foreign Exchange Regulation Act be considered a non-judicial processing on the part of the magistrate, such a non-judicial proceeding would still be within the scope of Order 13 Rule 10. In the circumstance, we cannot accept the contention of the Suencho as there was no proceeding and before the Chief Presidency Magistrate as requisition under Suencho be Income Tax Suencho. In Kailas versus Nahaku, reported in 2005 for SEC Suencho, all the rules of the procedure are the handmaid of justice. The language employed by the...
Mr. Decker.
Yes, my lord. Yes. So, my lord, admittedly, my lord, the first case I am relying, my lord, the former suit and the instant title suit is the directly and subsequent is issue. And so far as my second question is concerned, the court has ample power for calling off the record for proper adjudication of the matters. So same has not been done. So I am before this court, my lord. Obliged, my lord.
Yes.
Your lordship kindly come to page 23.
Page
Page 23.
23. Yes.
Schedule of the lordship.
Mm.
Schedule 2.
Mm.
Schedule 2 lordship may read. All the piece and parcel total petty land measuring 4 kata across appertaining such and such boundary lordship is dwelling house of the plaintiff in that number 147.
Mm.
West National Highway. Then your lordship kindly come to schedule of the claim in the earlier suit. That is at page 73. Schedule is not same lordship. It is vast area, dark number 135 and 147 vast area. Earlier lordship suit is respect of only 9 kata. Now it is 4 kata. And the lordship schedule of the land is different lordship. Earlier suit, your lordship kindly have a look at page 73. East, dark number 145. In the present suit lordship, it is dwelling house of the plaintiff in dark number 147. So it no way connected with the land of the earlier suit lordship. Earlier suit in that part lordship, it is dark number 145. Now it is 147. We are earlier lordship, earlier round of litigation prior for cancellation of this LD lordship. In that case, predecessor of the present plaintiff friend at the appeal stage. That is true, but we are not concerned with that part.
No, you say the DAG number and patta number are same.
Lordship, that patta are same.
DAG number
But
135.
boundary is different, and it is dark number 135 and 147 covers vast area lordship. We are not lordship connected with the land in respect of connected with the suit in title suit of 1990 lordship. That covers dark number 1 up to dark number 145. Now it is 147 in the eastern side lordship. So land is boundary of the land is not same. So in such in that view of the matter, how lordship it can be said that the subject matter in the present suit and the earlier suit is same. That is not at all.
No, you say in the earlier suit, in the eastern side, there is a land of DAG number 145.
Lordship.
And the present suit, it is DAG number 147.
Lordship. So it is no way connected. Boundary is no way connected. Earlier suit, land schedule of the land of the earlier suit and the present suit is different. Lordship. Schedule of the land is different. Boundary of the land is different. And other aspect, lordship, learned trial court lordship rejected the prayer for
No, Mr. Counsel, you see, some of the boundaries are also same.
lordship. Other part
Western side and National Highway. Here, western side, Silsor, Lokipur, Pirolidi Road.
It is same. It is same. But in respect of other, we are not disturbing up to 145. That number up to 145. After 9 katas, now dispute start. After 9 kata, now dispute start in respect of present 4 kata lordship, not with respect of earlier 9 katas. Now we are in possession of in that number 147 part of till date, and where my dwelling house is there, and suit land of the earlier suit from my dwelling house to that number 145. From my dwelling house to that number 145.
And west is same road, north
Road is
land
road
of
to
Dhanpat Singh.
western side.
Now Arjun Singh.
Lordship. Now it is a lordship in the present suit, dwelling house of the Arun Singh.
And south is same.
And
Puzon Singh.
earlier suit lordship, it is land of Dhanpat Singh. No way connected. It will be the land. South, land of Puzon Singh, it is same. but in north and eastern part, different lordship. And now only in respect of 4 katas of the remaining part where the petition right title and interest of the present plaintiff is there is a dispute with that part, not with the land that was already decided by the learned, already quoted by the honorable court in the earlier round of litigation. We are not lordship filing the present suit in respect of that land. It is not up to 145 lakh lordship. From the dwelling house of the present plaintiff lordship. Lordship, so nowhere can be said to be that both the schedule of the land of the present suit and the earlier suit is same. In other aspect, lordship, petition, their petition rejected by the learned trial court in the year 2023, lordship.
No, that's
That
all
is
right,
now
but
under challenge after
that
almost 2 years. lordship.
no, Mr. Mazumdar, you say while rejecting the petition, the trial court has not called for the record.
Record part
Without
is
calling
that
for the
call
record.
for call for calling for the record, my lord, that part I have no objection, that may be called for. But so far as res judicata part, both the after calling of the record and honorable court may look at the record and then can issue decide the issue lordship, whether both the schedule of both the plaintiff are the same or not. That is the lordship may interfere. But so far as 11 lordship, prima facie it is different. Schedule of the plaintiff is not the same.
No, in two sites, the schedule is almost same, and tag number, patta number same.
It is same. Dark patta number same, but there is a vast area in the dark number one.
The question is, in the earlier suit, the land was 9 katha,
Yes.
7 satak,
Lordship.
and in the present suit,
Then four kata.
it is 4 katha.
Lordship.
The issue is whether the present 4 kathas of land is incorporated in the earlier 9 katha 7 satak
Lord.
land or not.
That law court may decide that aspect lordship.
Yes, sir.
Lord, Therefore, my lord, we made an application for calling out the records, my lord, so that court could verify the record and of the schedule. Then court, may I relying the earlier declaring that the cases they not barred by res judicata is not absolutely wrong, my lord. So court could have called the records to verify the records whether it's barred by the 11 or not, my lord. That is also issue in my lord. So,
Okay, then in both the petition, we will interpret the orders and we will direct the learned trial court to call for the record and to verify the same and to pass a fresh
yes, my
order.
lord. Yes, on that line, my lord.
We will pass the order.
Yes, deeply obliged.
Like,
Next slide.
Item number 11.
Made previous color. Subject to what my senior says. I was subsequently engaged. There are few more documents which are ought to have been brought on record. There has a long checkered history. There are judgments of the year 1957 and 62. I could not really translate them. So if your lordship can accommodate me and have it right on reopening after, because they expressed urgency on the last occasion.
Yes, Mr. Mazumdar.
See, their stay has been obtained. Madam, by suppressing earlier facts that they filed a suit, and then in the suit we filed an application for rejection of the claim that was rejected. Our appeal was allowed against that, and appeal is pending. By suppressing all these facts, they have filed the revision, and this revision is directly against an order passed in a order 21 rule 97, which they have filed subsequently after rejection of their claim. Now, by suppressing all these things, they have obtained this is operant. The learned trial court has only passed an order to take up the question of maintainability of their petition in view of the fact that they are on the same, by the same party they filed earlier suit. In the suit, they initially filed matter that they say that I'm a tenant. Subsequently, the suit court claiming title over it, the land as on the ground of adverse possession. Now they have filed an application under order 21/97 saying that no, we will be a tenant. So by all these things, they are thus preventing the execution of the decree. There is a partition suit, preliminary decree is there, decree was passed long back, and now by filing this application, they have filed.
Long back means when?
When
When the decree was passed?
decree was in 2008. 2008.
8. Okay.
Now they are obstructing the execution by filing. the-
Execution case is pending.
Execution case is pending.
Yeah. Now, while execution has been going on, there are various flaws, various parties are there. And this on the behalf of this petitioner, earlier they filed a suit saying that we want title on the first position.
Hmm.
Before that, they filed an application under order 21 rule 97, similar petition
Hmm.
before the execution. Yeah. So these things were suppressed in this, my instruction, these things were suppressed in the present petition and then obtained a stay. Well, I'm just indicating two things. First, they filed order 21 rule 97
Hmm.
saying that they are tenant. Then they withdraw it, saying that we want to file a fresh suit. File a suit. In the suit, they say we have title based on adverse possession. There we filed a suit by showing all the things that we filed application for rejection of the claim that our application was allowed. Again, they preferred an appeal that is pending. Now, when there is pending, they filed another application under order 21 again, this time saying that I am a tenant. And the learned court below, after hearing us, my lord, has fixed the matter only for taking up the question of maintainability. Court has not decided. Court has only fixed the matter for taking up the question of maintainability of the petition in view of this background. Against that, they have come and obtained the stay. Let the trial court decide the question of maintainability.
My lord, first thing first, my lord, all that is already on record. I can show from the annexures that the suit was filed, the plaint was rejected, etc., etc. The moot question is this, my lord. The decree which is sought to be executed is a decree between the family members of one particular family, which is the Lala family. Now, in that, my lord, they obtained a partition decree. I am not a party to that decree or to that suit. In fact, my lord, I have a decree of 57 and 62, which had declared that their predecessors had filed the suit seeking my eviction. They had obtained a decree initially. Later on, that decree was set aside on the ground of fraud, and I was held to be entitled to possession, and they were injuncted, my lord. All these things were not part of the second suit that they filed, which is inter se between the Lala family, my lord. Now, the difficulty is, my lord, when I filed the application, my senior is absolutely right. We filed a suit, my lord. We filed a suit, the plaint was rejected. I can, but your lordship knows that insofar as execution of this decree is concerned, it has to be decided under Order 21, Rule 99. So regardless of whether I filed the suit or not, this application is maintainable. Now, what has happened is, my lord, the writ of delivery has already been issued. I have already filed my application under Order 21, Rule 99. Along with that, my lord, I filed an application under Section 151, bringing it to the notice of the court that since the earlier suit is dismissed, and I also have a decree way back in 1962 which protects my possession, therefore you hear my objections out under Rule 99, and until then, do not sort of go ahead with the writ of delivery. That was my limited prayer. Because if I take your lordship through the entire records, my lord, your lordship will find there are triable questions which have to be decided under Rule 101. So my prayer, the reason why we approached the High Court was that while my application under 21 Rule 99 was pending, the executing court did not even consider my prayer for an interim protection, my lord. Had your lordship not protected me, they would have executed the decree without even adjudicating on my objections under Rule 101, my lord. That is the reason why we are here, my lord. Otherwise, I can show, my lord, that we also had there was a checkered history where our possession was protected, my lord, and we had also reserved our right because we are in possession of two specific parcels, my lord. In one parcel, we are tenants. We are protected by a decree, and the other parcel has been in possession since 47 years, my lord. My version was never heard throughout that proceeding partition decree that they obtained, my lord. That was inter se between the Lala family, my lord. In fact, Lala family's predecessor, their own predecessor, had initially filed a suit for my eviction, which they had failed, my lord. They were unsuccessful. So therefore, without even going into these disputed questions, my lord, the executing court did not even consider my prayer, interim prayer for stay, my lord. All said and done, my lord, I have raised tribal issues. There are 3-4 judgments passed over the years, my lord. Without considering all of that, my lord, the executing court is insisting on an execution, my lord. That's my grievance, basically.
Okay.
Lord,
Then,
I bring all the
then-
judgments from 1957, which were
Mr. Decker, you
my lord.
say, can we dispose of this petition by directing the learned trial court, learned executing court to dispose of the petition filed by you?
Yes, my lord.
And thereafter to proceed with the.
Yes,
Yes, Mr.
I'll be
Madhav.
obliged.
Madam, we have filed an application, they have filed an application under 2197. When we have raised an objection giving the background.
Yes,
Anything-
both the, let the court dispose of both the petition.
Madam, there is one difficulty. If we file an application challenging the maintainability, that has to be decided on the basis of the allegations we have brought in our application. And if any objection is filed by them, take into consideration those reply. But order 21 rule 97 normally is taken up as a suit. There the trial will proceed, evidence will be recorded. In order to cut it short, we are saying it's not maintainable. Respond to that. If you have got any plea, please satisfy the court that it is maintainable. Thereafter, if they are not satisfied, they can always come here. But at this stage, when we have filed an application for challenging the maintainability, how can they come here and say, no, you cannot decide the maintainability? This is what they are saying, madam. We have filed an application challenging the maintainability. Court has fixed it. They have come before lordship. No, you cannot decide the question of maintainability. What about the background? And they are a tenant, my lord. Tenant is always bound by a decree, if any, passed by against their owner, landlord. He is by showing that he is a tenant. Once he is filed an application, suit challenging title over the property. Whether this court will countenance all this, my lord. You are resisting the decree once by filing a suit, saying that no, I have acquired title by adverse position. Then you don't succeed there, then you file an application under order 21.
Your petition is subsequent to the petition filed by him.
Yes. Petition, my lord.
This maintainability petition.
No, my lord, they have filed, when they did not succeed in the suit, suit was rejected on our application under order 7 rule 11. They filed an appeal. They should pursue the appeal. Now they filed order 21 rule 97, now saying there's no, I am a tenant.
No, you have filed an application questioning the maintainability of that petition.
Yes. And
So let the trial court decide that petition,
Yes.
and thereafter it will proceed to decide the petition filed by him.
yes,
But until then, that is the problem.
they, my lord, lordship is aware, my lord. If there is any decree, they are now in this, so far as this case is concerned, they are claiming tenancy right. You are bound by any decree passed against your landlord. How can you come? Then in every case, my lord, if there is a decree against the landlord, against the tenant, against the person, plaintiff will have to file another episode of, my lord, cases. This is not the law. You are bound by whatever decree passed against the landlord. Then by taking
No,
different
maybe
plea-
he has a right to file an application under that
Rule
97
21
petition.
That is correct. Order 21 rule 97.
So you cannot prevent him.
Cannot. We cannot. But when we raise objection about the maintainability of that petition in view of the background, that you earlier you have filed earlier a suit saying that I have acquired title by adverse position. When your suit is rejected, appeal is pending, you come and take a different stand. Say, no, I'm now tenant. Can it be done, madam? That is why we have raised an objection that your petitions are maintainable. Let the court below decide this application first. If this application is decided against us, then order 21 rule 91 will proceed. If it is decided against them, they can always come before lordship challenging that no, it is maintainable. But they are preventing the learned trial court to executive court to decide the question of maintainability which we have raised.
Mm.
And after they stay here, so everything will remain like that. So they need not pursue their suit and their appeal filed against rejection of their against the order passed in our order for 11 order 7.
Okay, till disposal of the petition, let there be stay.
And then the lordship will read this. Well, no, at this stage there is no threat. They are only trying everywhere they can to resist the execution of the decree. Well, Supreme Court is saying in one judgment, in a recent judgment, lordship just have a
No,
look at
that
this.
is that's a variable judgment.
But yes, but this is something on a different lordship.
Rahul Shah.
My lord friend is aware. This is 2021 660. Para 42.8, my lord. Para 42.8 minutes.
Yes.
Para 42.8.
Mm.
The court exercising jurisdiction under section 47 or under 21 CPC must not issue notice on an application of third party claiming rights in a mechanical manner. Further, the court should refrain from entertaining any such application that has already been considered by the court while adjudicating the suit or which raises any such issue which otherwise could have been raised and determined during the adjudication of the suit if due diligence was exercised by the applicant. If they have filed a suit, they did not take this plea, they have taken a completely contrary plea.
Mm.
Now they change the stand and file an order 21. It will be a never-ending process for them. Every time you change, you don't succeed, then you change the stand, file another petition under different provision of law. This is what they are doing.
No, the problem is that you cannot prevent them
No, my lord.
availing their right.
My lord, I'm not
Until the
preventing
same
them.
are
What I'm
exhausted.
saying is, my lord, when we file an application
Mm.
challenging the maintainability, let the court decide the question of maintainability first in view
Okay.
of this background. That is what I'm saying.
Fine.
I'm not saying that.
Okay, till a decision is taken on that petition,
My lord,
let there be stay.
My lord, once this order is there, they will protect for years together by taking adjournment, this, that. What I'm saying is, my
No,
lord,
no.
writ of delivery position has not been issued as yet.
Mm.
Lordship may pass an order that within 15 days they will decide. I do not want any.
Okay, till then, the interim order shall continue.
Once that interim order is not necessary because there is no writ of delivery of the matter. They are not going to be affected. Lordship will simply directly court below the thing decided within 15 days. And once your lordship passes this order, my lord, naturally, without disposing that my lord, in terms of a lordship direction, without disposing of that application, they are not going to do anything, even otherwise. How can they take part? And will not take any step. I am issuing, my lord. This is my instruction.
Let that be recorded, my lord. Writ is at page 20. Writ of delivery
Yes,
is
let it be recorded, will not
that
take
let them trial court decide
The lordship will
maintainability, my lord. But
direct-
until it
Give them-
decides,
My lord, lordship will give them a specific, learned court below a specific time within 15 days or maybe 20 days like that. Until then, I am assuring my lord on instruction that we will not take any steps for execution.
Okay, within 30th of April.
Well,
but till then, the writ should not be.
I am
Even if-
assuring, no further order may be passed. I am assuring on instruction.
My lord,
is
at
the
least that
assurance
has to
from
be
me.
recorded, my lord.
Yes.
The writ is hanging
Our
above
assurance-
my head.
Our assurance may be recorded, my lord.
No, the problem is that a writ has already been issued.
But that's what I'm saying, my lord. I'm assuring on instruction that till
Lord,
he is the local council. He is the
page 20, my lord. Page 20 of this year.
No, we have passed the,
Execution number 4 has been annexed. That order would be issuance of which will be taken made in title execution number 4 2000.
no, the writ issued by the executing court is a part of the record, part of this petition.
My lord, it has not been issued.
In fact, staff has gone twice.
No. My lord, also will kindly have a look at page 20.
Yes. So this is the read for possession of the land,
We
etc.
have filed, court has not issued.
Well,
We have submitted, court has not issued. My lord,
well, page 22, the Nazir has been directed. Nazir has given 2-3 reports, well, that it has visited.
Hmm.
Page 22, sir.
There is no order from the court.
There is a no, my lord, we'll see page 22.
Hmm.
This is signed by the civil judge. You are hereby commanded to put the decree holders in possession of the scheduled property by evicting the JDs and all the person bound by the decree. At the behest of this, we are sought to be evicted, my lord.
That's what I'm saying, Mayor. We are giving assurance that till this order, petition is disposed of, we will not take any steps, because we have to take steps. Only then the position will be delivered.
Well, it's more or less the same thing, my lord. Your lordship will clearly say that though the possession should not be taken over till the maintainability is
Hmm.
decided.
And it is the same court. If your lordship directs, your lordship direction will be complied with first.
Hmm.
That
Yeah.
much audacity the and courage the court, trial court doesn't have. Once your lordship passes an order that this petition may be disposed of within such and such time, and till then the council is.
And where is the petition filed by you? Page number?
My lord, page 28 is my application. Petition, I believe they raised it as an objection at page 83, my lord. And therefore, the court has fixed the matter for hearing on maintainability at page 98, my lord. So I think there is no separate application raising maintainability. They raised it in the objection itself.
Page number?
Page 983. 83.
In which paragraph it is stated?
Paragraph 1 itself, my lord.
Okay.
In fact, this is also misconceived anyway, my lord. The executing court will decide.
So, Mr. Mazumdar,
And
no separate
paragraph 7.
application is available.
Hello?
No separate application was filed.
Prayer is at page 88.
Well, prayer, lordship can say prayer is page 80. There itself we have raised the question of maintainability.
Okay.
And the order my learned friend is showing at page 22
Hmm.
is an order of 2019, not a fresh order.
That
So there is no application as such. Till the time your lordship directs that the petition should be disposed of, maintainability question.
Okay. We'll pass the order.
That lordship, the issuance of the. It was a partition decree and
You are for respondent number?
I am this for respondent number 8,
8.
19 and 14.
Okay.
Lordship, it is in 2 parts. It is a partition decree. It is in 2 parts, one for the decree holders and one for the debtors.
Hmm.
The decree holders part was executed in 2019.
Hmm.
And what they are claiming is for the under the JDs. Even though on inquiry of the regarding this details of the suit property, lordship will not find any description that is telling with the decretal property and the claim they have been making. No, sir, they are the decree and all they have been claiming. Even the petition they have made, it is not telling with the decretal property. The survey numbers are absolutely different. The boundary is absolutely different. In fact, their decree and whatever the documents they have produced is not having any survey number. Whereas a Saham has been prepared regarding the decretal property, which part is to belong to whom, and that is to be delivered in accordance with the Saham. Now, the claim they are making on the basis of the documents which they are referring is very much different from the Saham that has been prepared. Saham is with regard to the secondary patta number from which RS patta numbers they are arising from. Not a single document they have produced during the entire first round of litigation as to how they are having any property. Which survey number? Which is the boundary? That is not absolutely telling. A single document has not been shown that my land is attracted. That the land which is to be executed in respect of decrees to be executed is attracted. That is the position of the lordship. Any document my friend can show which relates to the decreed land which is to be executed. Any document. Not a scrap of document.
Okay. We'll pass the over.
Well, I stand corrected, my lord. Page 86 and 7 have also raised maintainability. My lord.
86 and
Page 80. So that application perhaps. 7 and 8 have also raised.
Maintainability question we have raised, right? So that you simply mentioned that we have raised the question.
okay.
Paragraph 13, decided on 26/2/2006.
Number 12.
May I please, your lordship? This is a transfer petition, lordship.
So you have filed your objection.
Objection, my lord. But it is not on record, my lord.
Okay.
Lordship, today, tomorrow is the date fixed before the learned court below. That's why your lordship has fixed today for consideration. And on last lordship, on 1/4/26 lordship, they have sought time for filing objection, lordship. And before that, lordship, may kindly see the 18/3/2026 order, lordship. Last line of the order at 18/3/2026, lordship.
Page number?
The order, lordship, of this court, lordship. Order of this court, lordship, of this case, in this case, lordship. First order, lordship, that order of motion, lordship.
Okay.
18/3/2026, lordship.
Hmm.
Last line, lordship, may kindly have a look, lordship.
Hmm.
So, lordship, the case is fixed tomorrow, lordship. And today, your lordship has fixed in a short date because the case is fixed tomorrow, lordship. And there is a prayer for consideration of interim prayer, lordship.
No, that's all right. If the objection is not placed on record.
But they have filed it at the last moment, lordship, and they fix it to the
When it
matter
was filed.
On today, my lord.
from today, lordship. They could have even mentioned in the morning also for bringing on record also, lordship.
My lord, then the matter may be stayed for the next, till the next date, my lord.
Yes, lordship. Lordship may kindly fix, stay the proceeding till the next date of fixing, because if the tomorrow is matter taken ex parte, lordship, then it become infractions, it will become infractions, lordship.
No, you can file an application before the court below
Yes, my lord.
stating that this petition is pending.
Lordship.
And we will not object that matter.
You can file an application there.
Lordship, because
Okay, otherwise, tomorrow we can take up this matter. Call for
Tomorrow
a-
is some problem, my lord.
if you have problem.
because on the first date order, that is why.
Heard, Mr. Abbas, learned
Lost.
counsel for the petitioner. Miss, your name, please?
PM Ahmed.
PM Ahmed, learned counsel for the respondent. The learned counsel for the respondent submits that she has filed objection in this petition today morning, and the same has not been placed on record. Accordingly, it is provided that recessal lays the matter on. Coming. 21st of April 2024, and take the objection petition filed by the
Can it be on
respondent
22nd,
hearing.
Lordship? Can it be on 22nd, Lordship?
Okay. And the learned counsel for the petitioner submits that the matter is fixed before the learned trial court tomorrow. And in the event of not staying the said proceeding, the court may proceed ex parte against the present petitioner, and in that view of the matter, he has contended to stay further proceeding of the title suit M number 113 of 2025 till disposal of this petition. Accordingly, taking note of the submission of learned counsel for the petitioner and also of the respondent, further proceeding of the title suit number so and so stands stayed till next date.
Lordship. Deeply obliged, Lordship.
Lordship, I pray for time being. May it be taken up at 2.
Whether notice was served upon respondent number 2.
In this regard, my lord, communicated, my lord, on 1/4 for the 26th day, taken, my lord. And accordingly on 2/4, my lord, from our office, my lord, it was sent, my lord. But because, my lord, because of law and order and my lord, company movement, I personally talked to the OC concerned, my lord. He prayed for an accommodation, my lord. My lord. They don't receive, my lord, they are not able to, my lord, serve this, my lord. It's okay, my lord.
So let it be after vacation then.
My lord, then
Heard,
Prefer-
Mr.
P.D. Chaudhary.
P.D. Chaudhary, learned counsel for the petitioner, and Mr. Osho for the respondent. Respondent number 1, Mr. Boisho submits that though notice was issued through the office of the public prosecutor, Gauhati High Court, and the officer in charge of the jurisdictional PS has received the same, yet service could not be effected on account of law and order situation prevailing in the jurisdiction of that police station. And accordingly, he priced for listing the matter after vacation,
But immediately after vacation.
immediately after reopening of the vacation.
My lord,
Pair allowed, rest shall list the matter immediately after reopening of the vacation. So do we fix it that?
my lord,
When?
preferably on 22nd, if possible.
21st.
My lord, 21st, we have a debt reference case, so.
22nd, this is on 23rd. Only, my lord, that part only regarding notice.
Okay, then 21st itself.
21st.
Obliged.
21st. Mr. Boisho shall obtain the service report from the
My-
jurisdiction officer in charge of jurisdictional PS. List accordingly.
Deeply obliged, my lord.
Obliged.
On Lordship. My senior is absent today, Lordship. Matter may be urgent for the day, Lordship. I will consent the other side, Lordship.
Item number 21.
21, Lordship. Take that. Take.
Okay.
Only Lordship, it's RSA of 2014. Any date immediately after vacation, Lordship, maybe.
Okay. Mr. Your name, please.
H. Islam, Lordship, on behalf of
Learned
BC.
counsel appearing on behalf of Mr. B. Sinha.
Yes, Lordship.
Learned conducting counsel for the appellant. With consent from the other side. Price for listing the matter after
Lordship, can it be fixed on 5th or 7th of May?
5th of May. Huh? 7th of May. As Mr. B. Sinha conducting counsel for the appellant is
Out of state.
out of station. Okay. Fair allowed. Rest shall list the matter on 7th.
I would like to mention item number 25. I am taking the consent from the other side and the possible for the day.
Miss, your name, please.
D. Goswami.
Learned counsel appearing on behalf of Mr. R. Goswami. Learned counsel for the respondent with consent from the other side. Press for listing the matter after vacation.
After vacation.
Fair allowed. Let's just list the matter on fixed date.
26th.
Item for hearing under order 41, item number 50. Item 15.
May I please, Your Lordship, I appear on behalf of Jia Ahmed, sir. Kindly adjourn the matter after beautification.
After
Beautification. Due to some reasons, my senior counsel,
you inform the other side,
yes, yeah,
you inform the other side.
no, I'm appealant.
Miss, your name, please.
Yes,
Your name.
Jan Khandagar.
Learned counsel appearing on behalf of Mr. Zia Ahmed, learned counsel for the appellant. Rest for listing the matter after vacation. Fair allowed. This is unless the matter after vacation.
Four.
May I please announce it? My lord, this is second appeal. Deferred against the order and decree, judgment and decree, that is on 22 and decree on 6/3/2026. And passed by the learned civil judge senior division. Affirming the my lord judgment and decree dated 4/4/2020 passed by the municipal number 2 of testimony. By which my lord the title suit number 6 of 2026 was dismissed. But here the my lord, I mentioned the grounds. They basically my lord the ground number 2, then 3, then 5, then 6, 7, and my lord 10, 9, and 11, my lord. This is the basic grounds, my lord. The question is involved that whenever, my lord, the defendant has taken the stand, that land, my lord, the by which notification of eviction notice I was thought to be evicted has been acquired by a government process of acquisition of land, then they, without proving the documents relating to, my lord, the notification regarding the land acquisition, my lord, going to acquire, then without having any considering objections and payment and receipt of the payment, the land acquisition is complete or not, my lord. So on the basis of that, my lord, I have framed it, and as well as the, my lord, during the time of filing the second appeal, my lord, one on view of one application that has been filed by the predecessor insurance of this land in the year 1991, my lord, regarding that the land he's possessed more than, my lord, the his actual possession was, my lord, 4 katha 11 dasa, out of which, my lord, 2 katha was acquired by government during that process. But by mistake, my lord, the entire land instead of 2 katha has been, my lord, shown as a, my lord, government land by one, my lord, office note that is to 1988. So they said that that may be corrected because that is only in respect of the 2
Whether
katha.
any writ petition is pending concerning the same matter?
No, my lord. This matter is totally different, my lord. So substantial question is, my lord, the basically frame on the, my lord, grounds number 1. Lordship will get page in 9. It is started. 2 and 3. 3 are the main, my lord, the important substantive question, my lord, because during the time of the second appeal, one application was filed by 41 under order 41 rule 27 for, my lord, additional evidence. And the
Second
lordship,
appeal or first appeal?
my lord,
Second appeal or first appeal?
during this first appeal, my lord. So in that case, my lord, the learned first appellate court, my lord, they, without following the mandate of the Supreme Court in Ibrahimuddin case, that if some, my lord, application is filed under 41 rule 27, that to be decided at the time of the final hearing and disposing of the appeal. So that was not done. That was
Where is
separate,
that application?
my lord.
Where is that application?
But I'll annex the copy of the order, my lord.
Page number?
It is a last annexer, page number. It is started from 109. Petition was not examined. I have given the only annex document of the judgment, my lord. Passed in relation to that case. By which, my Honorable High Court, this judgment dated, my lord, 6/6/2025. Specifically, when a direction was given to the trial court, like this first appellate court, to take into account that application at the time of the hearing by reviving the miscase which was disposed of earlier. With the mandate of the Supreme
So
Court.
the
given-
miscase was revived? Miscase was restored to the file?
Yes, restored to the file. And that,
Thereafter, opportunity of
was
being heard
given,
was afforded
yes.
to you?
But,
Thereafter, no order was passed?
no order was reflected in the final order, my lord. And moreover, my lord, the Supreme Court also, my lord, in substantial question is framed on the basis of the my lord, Supreme Court judgment, is ditto with me. But where the Supreme Court says that if the my lord, the land acquisition process, respondent is failed to produce any proof of payment, my lord, is made, I have received the payment, and objection raised by the my lord, or consent letter is raised by the my lord, the person whose land to be sought to be required. So without proving these things, mere my lord, the covering one, sending one, proving one covering letter is not enough. So in my case also, the defendant, while they have taken this stand in a written statement that land has been acquired by a process of this and these things, but they've totally failed to bring in the record the notification, simply mention the notification number, but no copy. Well, there is no any specific kind of proof that the payment was made in respect of the entire land and payment was received by the person concerned, nothing was there. So on the basis of that matter, I have framed this as a substantive question of law. The judgment also I relied. This is the judgment, my lord. In Ibrahimuddin case also, it is a my lord, binding my lord, upon the my lord, respondent. This is the judgment. It is Sikkim case, my lord. I am sorry, my lord, I have some marking has been made on this my judgment. Lordship may come to my lord, this first my lord, my marking, then the last one, 19 para, probably one, 19 and 16 one.
Yes.
So in that case, my lord, it is very much clear that if any proof is not there regarding the land has been acquired, so mayor issuing a notice, that is exhibit my lord 1 and 2, that my land is, I have acquired my lord, this land illegally in spite of the land has been my lord, acquired by long back, but it is not, my lord, it should be the case of the defendant on basis of which my lord, my title should be dismissed, my lord. And the Supreme Court says in that failure, government has to go for either two options. Either they have to give me the mission profit or they can go for the face. So my,
Are you sure that this order?
Yes,
no,
yes,
this
my lord, sure, my lord.
application under order 41 rule
No.
27 has never been considered
Nah,
in
nah,
the judgment?
kindly see the judgment. my lord. Judgment is not reflecting anything regarding that. Nothing has been there. Even my lord, that case I referred also in that hearing, my lord, I personally had my lord, presented the hearing. The judgment also not reflected, my lord. No whisper about this, my lord, order 41 rule 27 petition, my lord.
No, there was one miscase
Yes,
upon the application filed by you.
during the pendency of the first appeal, my lord.
Yes, that application was not disposed of.
Initially, my lord, they are violating the my lord, mandate of the Supreme Court in Ibrahim case, my lord. That is my lord, discussed in this case also, and separate my lord, judgment also there. I can, if lordship provide, where it is saying that if any petition is filed under 41 rule 27 for additional evidence, that should be taken into at the same time while the my lord, final my lord, judgment is.
No, that's all right. There is no dispute about it.
Yes, my lord.
But the question is whether that miscase was disposed of or not.
Initially, that's what disposed of separately, my lord. Against that, my lord, we have come before the High Court. So High Court, my lord, by this order, they're saying that I am reviving this case. This will be considered at the time of the final judgment of the my lord, first appeal. So that was not there.
No, thereafter, what happened to that Ms. J case?
Mrs. Kevlar revived, my lord.
No,
By-
revive.
Yes, my lord.
But at the after disposal of the appeal, what happened to that Ms. J case?
Automatically, my lord, if the my entire my lord, appeal is dismissed, that will go also, my lord. Because there is no, my lord, any whisper of any other things, my lord, there. In judgment, that should be there. that I have taken into account this also, I have taken consideration of this petition also. Whether it is the additional evidence is required or not, there is nothing is there. And moreover, my lord, so far the Supreme Court mandate is there that the land acquisition process, whenever they have burden shifted to defendant, as per the section 101 to 13, that is the discharge to be by the defendant. That is not discharged by them. They are mere producing one Jamabandi copy and relying on Jamabandi copy that there is a note that also, my lord, subsequently that was made, that saying that in view of the, my lord, land acquisition notification such and such, and on the basis of the land acquisition case, this land has been, my lord, made a government. And moreover, interesting thing is that, my lord, as per their stand, the land was acquired for building a, my lord, constructing a road, National Highway 37A, connecting, my lord, Kolyabhumura Bridge. So if the land, suppose, my lord, the land, for a moment I am accepting that this they have acquired. So they say the land is 4 kata 14 lesa, dag number such and such, patta number such and such. This is a, my lord, combined compact land. If, my lord, 2 kata land is acquired, then, my lord, remaining land it must be attached with the first, my lord, the highway. So admittedly, they have also stated by this land, whatever now they are going to take by way of this notification, try to evict, that is 150 feet away from the highway. So that cannot be at any sense, my lord. If the land part of the land has been acquired and other part they have, suppose both entire land has been acquired, suppose other construction for the purpose of the construction 2 kata has been utilized and remaining 2 kata 14 lesa was lying, that should be always in the adjacent to the highway, my lord. That cannot be 150 feet away from this.
No,
This
that's
is-
all right. The question is, if that miscase has not been disposed of,
Yes, my lord.
then perhaps we can interfere with the impugned judgment
Yes, my lord. This is
and
the,
we may remand the matter to the
yes, lordship can,
appellate court.
whatever lordship think better, my lord. But think is that, my lord, the main substantive question I framed the number 1. This is a vital one, my lord.
Mm.
This is a vital one. They have to prove whenever onus goes to them, their responsibility lies with them. They have to come with all the evidence, with the documentary that this land was acquired by this notification. This was the objection or consent letter of this landowner. This was the, my lord, payment made to account this one. They have received the amount by this. Nothing is there. We said admittedly, yes, land was acquired 2 kata. 2 kata has been acquired and that has been made. But after remaining 2 kata, remaining 2.14 lesa, that is, my lord, not acquired. So it made the application to correction the land record. And that was filed in 1991. That was filed in 1991, but because of that predecessor interest and ill issue, that was not pursued. That when the suit was going on, in the time of the first appeal, that was brought into record that this was stand was there, that there was the application, but the record was not confirmed. So they afraid that there is no, this is in titles, the trials court, we could not produce the due diligence, so we are allowed to bring this record. So that petition was separately taken into account and dismissed. Against that, we have come before the High Court. So High Court say no, at the time of you disposing the entire, you have to take into account. But that was not there. It is very clear, my lord, judgment. If the lordship, my lord, wants to remand, my lord, that can be remand, but I have no objection. But thing is that, my lord, substantial question, wherever I framed 3 substantial questions, these are the very vital substantial question, my lord. Because one is
No,
based on
that's
the
all right.
Supreme Court judgment.
If the petition filed under Order 43, Rule 27 has not yet been disposed of at the time of hearing the appeal,
That is
then,
the enable is there.
are
Enable
you
is there.
sure that no order was passed in that?
Like lordship can go through my judgment. Well, I have
No,
personally.
maybe whether by a separate order the same has not been disposed of.
Decree has been initiated, my lord. After the decree has been issued.
Okay, then I will examine the order. No, examine the appellate court judgment.
My lord.
Thereafter pass necessary
My
order.
lord. And moreover, my lord, if lordship, my lord, is not satisfied about the substantial question, wherever is framed, my lord, on the basis of this, my lord, my second will survive. So on that issue, my lord, I have filed one IA also for stating, my lord, this.
Okay, if we admit the appeal, definitely we will consider your IA.
My lord. My lord. Master.
Items for hearing. What number?
That's তো তেজপুৰৰ ৱেবছাইটত ফটো ষ্টেক কৰ ষ্টেক যদি আছে এই কেছটো ডিছপ'জ হ'ল নে নাই চাওকচোন এবাৰ
On last occasion, Lothip, I have completed my argument. And
Yes.
Lothip has given it, he also completed his argument, only Lothip has a chance to look at the judgment placed by me.
Yes.
And I can reverse the, Lothip, my statement, my submissions. What is the actual fact? If Lordship,
No, not necessary to reiterate the facts. You give me the judgment.
already I have placed the judgment, Lothip, he have to give the reply.
Okay, on the judgments. Okay. Okay.
এটা জন্য দেখলাম লিলিস এর ওকে হ্যাঁ দিব কোনে মই তাতে কোটো লিলিস আপনার এই কোনে আপনার জুনিয়র লিলিস এই কোনে
Yes, Mr. Ali. Okay. Nothing.
May I rephrase the facts again?
You have not given him the copies of the
Lordship,
list of cases.
Lordship has given me to take the reference from court. He has taken, his junior has taken the judgment from my, from my.
Both side produced for us. So we have taken our judgment back.
Now, are you in a position to
I
answer?
have not gone through this.
Then what to do?
Otherwise, both sides completed.
He also placed his judgment, I also placed his judgment.
No, the judgment produced by Mr. Goswami is available on the record, but your judgments are not available on the record. Whether you have
He has taken
produced,
back. He has taken back. He has taken back from the honorable court on the same day.
why?
I do not know, Lordship, because court has directed to give a reply to the judgment placed by me.
Hmm.
And that is why Lordship has adjourned the matter and fixed the case today.
Hmm.
Junior leadership. बोला था ना कोर्ट का सामने किया था कोर्ट का
My learned friend placed the judgment regarding the boundary.
Hmm.
He is disputing the boundary. May I check the fact, madam? He's here. Because our cell did tally with the boundary and it was accorded by the tripod as well as state court, my lord.
Hmm.
The findings, my lord.
My submission was that, Lordship, he has purchased 3 quarters of land. And she has given the boundary of the total 3 acres of land in the sale deed. Secondly, he has not challenged, as a plaintiff, he has not challenged my sale deed executed by Prabodh Halloy, which is on the record. And he has argued on the point that in the trial court has held that my sale deed was not proved by calling my vendor. My sale deed is a 30 years old document. I have produced the registered sale deed before the honorable court, registered certified to be registered, say original sale deed before the honorable court. I have called the witness who has signed as a witness in the sale deed. He was examined, but I have not called my vendor. And that is a 30 years old document. Section 90 of the Evidence Act said.
No, that's all right, but the contents has to be proved. Contents has to be proved
Content has been proved by me.
by examining.
By examining
One
myself
witness.
and by a witness who has signed as a witness.
Hmm.
I have also proved the signature of my vendor.
Yes, yes. So your decisions are not with you now.
On the last proposal, my learned friend, my lord, take the plea that boundary is not taken, my lord.
Hmm.
And on that point, my lord, judgment was placed, my lord.
Hmm.
But our submission was that, my lord, in the both the courts, my lord, to the documents, my lord, original CD as well as subsequent CD, my lord, and the boundaries tally, and it was according to the finding. And regarding, my lord, the heat for the sale deed, my lord, which was
No, Mr. Ali,
lordship.
you have completed your argument.
Lordship.
Today we fix the matter only to reply in respect of the judgments referred by him.
Lordship.
So where is your answer now? You are again reopening the facts.
Lordship may take up more, my lord.
Tomorrow may not be possible because there is an order of the of the Chief Justice to list all the pending motion matters.
Or during the-
So tomorrow.
Oh,
So it may not be possible tomorrow.
because as it is part of the lordship and
Okay, কিমান হবে? অনুমান দিন না।
or immediately after reopening, my lord.
Pardon?
Or immediately after reopening, my lord.
Lordship, I have no objection. If Lordship, it is Lordship discretion, Lordship can, because already that argument has been completed. He can also give a written argument to the Honorable Court. Registry.
Okay,
Oh, that I
you
can.
can give the written argument.
Written
also.
argument. Lord. Tomorrow he can submit a written argument.
Tomorrow possible.
He has also already completed the argument, only judgment.
The judgment he has to reply.
Then you have to take the meter punishment.
Or Mr. Gustami, learned counsel for the appellant, Mr. Ali, learned counsel for the respondent. Arguments concluded. However, Mr. Ali, learned counsel for the respondent, shall reply in respect of the decisions referred by Mr. Gustami, learned counsel for the appellant, on 21st of April. List the matter as parted.
Obliges.
24. I am sorry, my lord.
My lord, regarding Lordship inquiry and miscase, I have now seen online manner separately this has been disposed of.
Dispose of.
Separately.
Then
That is rejected.
that substantial question may not
Other, the
arise.
first subsequent question will be there.
Okay, we'll see.
I was just sick, my lord. Then I confirmed that from miscase there is separately disposed.
Okay.
Must have been.
May I please, the lordship. So judgment of reversal, lordship, this substantial question of law which has been formulated, it is there at page number 5. The appellant, as the plaintiff had filed the suit, as with a prayer for a decree declaring the monthly tenancy in respect of the premises described in the schedule below, under the defendant a monthly rent of rupees 800. Now the substantial question of law, Lordship, it is there at page number 5. Basically, there is a misinterpretation of the evidence on the documents on record. And this appellate court misconstrued the provision of section 101 of the Evidence Act. And this contravention of the provision of order 41 rule 31 Lordship.
Oh,
This
whether,
order 41 rule 31 Lordship, all issues were not properly dealt with by the learned law appellate court Lordship.
but is there any discussion in respect of the issues?
No, Lordship, there is no discussion. That is the reason why the substantial question of law was formulated, Lordship. The issues are
That's
framed
alright.
with regard to while the reversing the issues of the learned trial court. Lordship.
Appellate court has not formulated any point for determination.
Yes.
But whether any discussion was directed in respect of the issues framed by the trial court?
So issues, all the issues are not discussed. That is the reason why, Lordship, this order 41 rule 31 has been taken into account, Lordship.
No,
But if-
individually, all the
Yes.
issues may not be discussed.
Yes, Lordship.
But whether any discussion was there?
Lordship, kindly see the appellate court judgment, Lordship. Then straight away I am going to the appellate court judgment.
Hmm.
This issues at page number 44. Page number 44, Lordship. The paragraph number 8. This learned law appellate court mentioned about the issues starting from issue number 1, Lordship, is whether there is any cause of action, whether the suit is maintainable, whether the predecessor of the defendant executed Ekranama, whether the plaintiff is a monthly tenant in respect of the premises, whether defendants are bound to deliver possession of the premises as per the terms of the Ekranama, whether the plaintiff is entitled to any other reliefs. Now the discussion, Lordship, the points for determination are, it is at page number 46. And accordingly jotted down these points for determination with regard to only one issue. Whether the decision arrived
No,
at
may not be. The learned trial appellate court, first appellate court has discussed all the issues framed by the learned trial court. It appears.
Yes, Lordship.
How many altogether 5 issues
5, 6
are
issues.
there?
Yes.
And those were discussed by the learned trial court.
Exactly.
Sorry, appellate court.
Whether the decision arrived at by the learned court below are in fact and law and sustainable in the eye of law. Because while this particular issue was jotted down, Lordship, with regard to this discussing all these 6 issues, the learned law appellate court, it came down to only one issue. Then the aspect of the matter with regard to the evidence, appreciation of the evidence is missing, Lordship, because when discussing with regard to the fact that whether the learned lower court are in fact and law, the relevant issues or the relevant evidence which were there, which were relied on by the plaintiff or the defendant at the relevant point of time, these were not taken into account by the lower appellate court, Lordship. And this is the perversity of finding, Lordship.
No, maybe.
Yes, Lordship.
First come to the
Yes,
second
I'm just coming to the second substantial question of law. This is with regard to the fact that the lower appellate court misconstrued the provision of section 101 of the Evidence Act and thereby arrived at an erroneous finding. Now, why this particular substantial question of law was formulated, Lordship? Because the plaintiff had discharged his bounden duty to prove his case. Now, to rebut the contention of the plaintiff, now it is for the defendant to disprove.
No.
And yes, Lordship. Shifting of the burden.
Come to this substantial question number 2.
Yes, Lordship, that is what I am submitting, Lordship. Learned Lower Appellate Court misconstrued the provision of section 101 of the Evidence Act and thereby arrived at an erroneous finding. That is with regard to the proving certain facts. With regard to proving certain facts, Lordship, the plaintiff, by adducing relevant evidence, had proved certain relevant facts. Now to disprove those facts, now it is the shifting of burden lordship. The shifting of burden or the onus lies upon the defendant. But the defendant, there was no such evidence on the part of the defendant. And that is the reason why lordship, the initially at the trial stage, the suit was decreed. But while reversing the finding of the lower court lordship, the lower appellate court did not take note of all these relevant aspect of the matter lordship. And this is another perversity of finding. Only
No.
two, yes,
You see, you come to Rule 31,
yes,
Order 41.
yes, lordship.
Please, it do.
The judgment of the appellate court shall be in writing and shall state the points for determination, the decision thereon, the reasons for the decision, whether decree appeal from is reversed or varied, the relief to which the appellant is entitled, and shall at the time that is the pronounce be signed and dated by the judge or by the judge concurring therein. Now here in
Here,
this
point for determination has been formulated.
lordship, the points for determination, the decision thereon, the reason for the decision. Now, while arriving at a finding with regard to the reason for decision lordship, the learned lower appellate court, this while determining these points for determination with regard to all the issues, because the relevant issues which were framed lordship with regard to the fact that whether the defendant executed acternama is a monthly tenant, this relevant aspect of the matter has not been dealt with lordship. I'm just referring to the judgment lordship. May I go through the judgment? This will
Issue-wise,
clarify.
the appellate court has discussed all the issues.
Lordship, kindly I'm just reading this paragraph, page number 46. Page number 46, and how it has been taken into account by the learned lower appellate court lordship. This with regard to the issue number 2, this page number 47, paragraph number 15. This issue with regard to the maintainability of the suit, and that has been upheld by the learned lower appellate court as well as by the learned trial court. Now the issue number 3 is whether the predecessor of the defendant executed an acternama dated 12/4/2004. It can be seen that the plaintiff in his plaint as well as in his examination in chief stated that he was a tenant under the predecessor of the plaintiff since 15/12/1984 and has been paying his rent regularly. Thereafter, the predecessor of the defendants gave a proposal that the existing Assam type structure would be demolished and the RCC building would be constructed. And consequently, the plaintiff by an acternama vacated the suit premises, and it was agreed that he would give an advance of rupees 75,000 to the predecessor of the defendant in 3 installments, and thereafter gave rupees 25,000 to the predecessor of the defendant. And same was received by the defendant number 3 at the instance of the predecessor of the defendants, and the agreement was entered between the parties on 12/4/2004. PW1 also stated that predecessor of the defendant signed on the acternama on the first and the last page, and the other pages were signed by the defendant number 1 at the instance of the predecessor of the defendants as he was ailing. The defendants denied the execution of any agreement on 4/2004. They denied that the defendant number 1 had put his signature on the other pages of the acternama. From the case in hand, it appears that there was a tenancy agreement between the plaintiff and the predecessor of the defendant. As such, the signatures on the paper transaction should have been between the plaintiff and the predecessor of the defendant. But here in this case, this was not so. Here it is seen that the first and the last page bears the signature of the predecessor of the defendant, and then the other pages bears the signature of the defendant number 1. Hence, it is found that the said acternama is an incomplete one, and hence the defendants are not bound by it. Hence, this issue is decided accordingly. Now,
So reason is assigned by the
exactly, lordship. Now this particular aspect of the matter, how it has been dealt with by the learned trial court, lordship, kindly peruse that aspect. The learned trial court.
Mr. Sodure,
Yes, lordship.
we are now dealing with the substantial question number 2.
Yes. 2 is with regard to the shifting of burden.
Is it?
Yes.
Substantial question number 2.
Oh, question number 2, yes, with regard to order 41 rule 31.
Yes. Now the question is, we have seen the learned trial court has formulated only one point for determination.
Yes.
But it has discussed all the issues with reasons. Now, where is the second substantial question of law here?
that is what I'm submitting, Lordship. This learned trial court, while discussing this particular issue, had dealt with the evidence
It
part.
has assigned
The lower
reason.
appellate court has not dealt with the evidence part, Lordship, merely saying that these particular signatures were by the predecessor of the defendant and the other pages were by the other party, the present defendants. So what is the reason for that? This can be ascertained only from the evidence on record, but evidence on record has not been taken into account by the learned lower appellate court, Lordship.
Why?
Merely saying that these pages
No,
contain the
we are still in the substantial question
Exactly,
of law
Lordship.
number 2,
Yes.
not in 1.
Reasons for the decision, Lordship.
So
Reasons for the
is it
decision.
not a reason?
Reasons for the decision. If
Is
you
it
are
not a reason?
no, Lordship, why it is not reason, Lordship? Because to arrive at a particular reason or to reverse a particular finding.
No, reason may be justified or may not be justified.
Yes.
The question is, there exists reason.
Yes. To some extent, there exists reason. But I am saying the order
whether
41.
this
Yes.
order
41.
Order 41 rule
31.
31 is not complied with now.
No, Lordship, the reason I'm just again referring to that particular aspect of the matter, Lordship. Order 41, Rule 31 mentioned about the reasons in case of this reversal of the finding. Now, the reversal of the finding with regard to this particular issue, that whether whether the predecessor of the defendant executed an Akrarnama. Now, this is the issue that was framed by the learned trial court, Lordship. Here in this case, the learned lower appellate court arrived at a finding.
Maybe we
Yes.
consider that aspect while dealing with the substantial question of law number 1. But coming to the 2, whether the requirement of rule 31 is not complied with by the learned first appellate court.
No, while reversing, Lordship, because this issue, the finding of the learned lower appellate court is not commensurating with the issue. Because issue is whether that was executed, the specific issue was there, whether the plaintiff, whether the defendant, predecessor of the defendant executed the Akrarnama. This is the issue. But here in this case, lower appellate court came to a finding that the last page bears the signature of the defendant number 1, hence it is found that the said Akrarnama is an incomplete. This is not the issue, Lordship. He has completely traveled beyond the issue, Lordship. Because if he has traveled beyond the issue, that means there is no reason, there is no finding. Because if I am saying rightly, wrongly,
I have already told you that reason may be justified or may not be justified.
yes, I can understand that, Lordship.
But the
Reason may be
question
justified
is,
or may be
is there any
justified.
reason or not?
Yes.
Reason is there. You could not follow.
As per my understanding, Lordship, reason is not there because the issue
No,
was with regard
is
to.
this not a reason?
Because predecessor, the issue was whether the predecessor of the defendant executed the Akrarnama. Because our contention was that was executed by the predecessor. Since it was executed by the predecessor, it is the bounden duty of the legal heirs to abide by the terms and condition of that Akrarnama. This is our contention in the plaint. But the learned lower appellate court came to a finding this is an incomplete document. This is not the issue. Whether it is an complete document, incomplete document, this is not the issue. Whether it was executed by the predecessor of the defendant. That was the issue, but that has not been taken into account by the learned lower appellate court. That's why I said that the issue was framed. Maybe this is my wrong understanding, Lordship. But as per my understanding, this is order 41, rule 31 not complied. Because if you are saying about
better you go through one decision.
Yes, Lordship.
Mugendro Indrovan Mehta versus Gujarat Municipal Corporation. That decision. Mugendro Indrovan Mehta. On the other day, you have taken it out.
I will also rely on one judgment, Lordship. If the issues are not properly addressed by the learned lower court, by the lower appellate court, then it goes beyond this provision of order 41.
Of which year?
Yes.
That decision is of which year?
I'm just giving the decision, Lordship. Good night. itu উপর লেখা আছে
Mukendra Indrapan Mehta. Inna ulai disil na eta apuni? Itu justice or Bhupan na আছিল. You produce the decision you have relied upon.
Lordship, I'm sorry, Lordship, I'm not carrying the judgment. I was under the impression I'm carrying that particular judgment, Lordship. I'm not actually having that judgment. Lordship, I'll go through that judgment. Lordship is relying on.
Okay, I'm giving
Yes,
you the citation.
Yes, Lordship.
Paisa nahi. No, no, sir. That is citation to থাকে no.
Evidence
SSC.
copy to assume notes. Evidence to assume stitch করা।
CA number. কিমান? 16 1 16 SLP numbers of the year to KSL. Huh? Mr. Soduri,
Yes, Lordship.
it is civil appeal number 16956 16957 of 2017.
2017, Lordship.
In the last portion of the decision, the requirement of this
Order 41.
order 31, no, order
41,
41, rule 31 has been discussed. And here the finding of the court is that even though the appellate court has not formulated the point for determination yet, if it has directed discussion to the issues, then it will not be fatal. Paisa das? It will. Okay. Then you come prepared on that point. Then you bring your decision.
Yes, Lordship. I'll bring my judgment. Because this is my only contention, Lordship. In the trial court discussed the entire issue, Lordship. All the witness, even the DW1 admitted the fact that he put the signature in the Akrana.
Here there is concurrent finding of fact of both the court below.
No, Lordship. This is a judgment of reversal, Lordship.
Reversal.
Trial court decreed the suit in my favor, Lordship.
Okay.
And the issues with regard to the whether the signature was put, because there is a specific admission on the part of the defendant, Lordship, that it was duly signed by him, Lordship. When it was signed, because this is with regard to the based on the agreement. And I was evicted from the this particular suit premise only on the ground that after construction of the building, I will be handing over this suit premises, Lordship. Thereafter, it was not done. Even the payment was received. So this is the only case. Lordship, after vacation, Lordship may fix a date, Lordship. I will come up with the judgment, relevant judgment.
Heard Mr. SP Chaudhary, learned counsel for the appellant. Mr. Dekar, learned counsel for the respondent. Heard in part. Leaves the matter on. Good. 7 May.
Obliged, Lordship.
Number 26.
I'm sorry, Milord. So did it. Can you tell 12 of May, Milord? 12 of May, Milord. Deep,
You please inform him.
yes, so 12 May.
May I please, your lordship, my senior is on legs, lordship. Can we fix a
Date, another date, Lordship.
Lordship, this is a partnered matter.
My payroll's order is 5/3/26.
Okay, it will go to the appropriate bench.
Lordship.
Heard, Miss?
D. Devi, Lordship.
Learned counsel for the appellant and Mr. Singh for the respondent. Mr. Singh has pointed out to an order dated 5/3/2026 passed by a coordinate bench of this court and submits that the matter is parted in in that bench. Accordingly, it is provided that recessal list the matter before appropriate bench
Lordship, but date will be fixed, Lordship.
after vacation.
27. Yes, Lordship.
May it please your Lordship. Your Lordship, due to medical urgency, my senior had left the court early, your Lordship. So kindly accommodate us today for today, your Lordship. We have informed the other party, your Lordship.
As agreed by learned advocates of both the parties, recessal list the matter after vacation.
Obliged.
Item 28.
That's Lordship. Also, I have engaged in this case only for the Lordship. No time may be given for final.
Mr. Sheikh, any objection?
My lord.
Heard, Mr. MSA, learned counsel for the appellant, Mr.
And Board Lordship.
And
And Board.
Boro, learned counsel for the respondent, Mr. Boro submits that he is engaged in this matter today.
Yes, Lordship.
And he pressed for listing the matter after vacation so as to enable him to go through the record. They are allowed to recessal list the matter after reopening of the vacation.
My lord, after vacation, my lord, a date may be fixed. My lord.
On 19 May.
19 May.
Item 29.
29.
May it is Lordship.
Mm.
My lord, this is second appeal, but not concurrent finding. In the first trial court, there was the decree, of course, decree that the money should be returned to the plaintiff. No registration of the land was ordered.
The suit was filed under the specific.
SPS, my lord. So the learned trial court granted relief to the extent that the money which has been taken by the present appellant should be returned to the plaintiff on the ground, mainly on that the agreement which was executed between the two parties in that land, there were other brothers, other co-sharers. So without getting the person's name mutated separately, he executed the agreement. That was the finding. So that was one of the reasons. And another reason was that the agreement was also not so in violation of certain laws, section 44 of the Transfer of Property Act, etc., etc. Now, ultimately, the learned trial court ordered that the present defendant, who is the present appellant, shall return the money to the respondent plaintiff at the trial court. But the respondent was not happy with that. He filed an appeal before the first appellate court. An appellate court, quoting different citations, said that a specific performance should be allowed and the land should be given in the possession, shall this should be executed, and accordingly the other possession, etc., as required under law should be handed over to the respondent here in this appeal. Now, in between, they say that we have handed over the land to them. But actually, that is not correct. The land is still in our possession. Of course, they one day, sometime they came and constructed a small house in my absence. That was objected. So after all, the land is in my possession. So the land is completely now in our possession. Now, Lordship would kindly see page 7. I am reading para 1, that the defendant being in need of money offered to sell his 2 kathas 5 lesas of land covered by dag number so-and-so, PP number so-and-so of Diuriguri, Kisam, Mouza, Nish Shahar, District Nogang, Assam, and the plaintiff accepted the offer of the defendant, and an agreement of sale of land has been made between the plaintiff and defendant. The details description of the suit land has been given in the Schedule A.
Mr. Mahmood, sitting in second appeal, this court is not entitled to re-appreciate the evidence on the record. Here, we are to see only the substantial question of law. You come to your substantial question of law.
Formulated by was formulated that Lordship may be seen. There were several 4 substantial questions of law. Whether the first appellate court committed grave errors of law and facts in not discussing and deciding all the issues framed by the learned trial court, being the final court of facts, though reiterated in the appeal. This is one. Second, whether the defendant appellant had the legal right, the present appellant has the legal right to execute a registered agreement for sale in respect of land measuring 2 katha 5 lesa covered by dag number 316, 356, 360 of Patra number 62 of Dimori-Guri Kisam, Mouza, Nish Shahar, District Nogang, Assam, where there are many other co-patradars owners in the record of right Jamabandi without making them as parties. Whether the appellant defendant who executed the alleged agreement with the plaintiff respondent can be asked to register the sale deed in favor of the respondent plaintiff when the land does not retain absolutely only in his own name and without making the other legal heirs of Abdul Kader as parties, and also without determining his individual shares over the suit land. Whether in absence of any finding of the learned courts below regarding the genuineness of the agreement for sale and signature of the appellant on Exhibit 1, Bainanama, can direct the defendant appellant to execute the sale deed in favor of the respondent. Regarding 4, I do not want to argue because we did not file any cross appeal. So 4, you are not hesitating. Now question is this, my lord. Now, Lordship, kindly see for a moment.
Come to the substantial question of law number 1.
Yes. First of all, grave errors of law and facts in not discussing and deciding all the issues framed by the learned court, being the final court of facts, though reiterated in the appeal. So, my lord,
let us go through the judgment of the appellate court.
Judgment of trial court.
Appellate court.
Appellate court. Page 23. Here, the case of the defendant. That is our case, my lord. Page 25. The statement that the
No,
defendant being
no. Whether any point for determination was framed by the
yes, that
learned
is the
appellate court?
also that issues are the page 26, man. Issues are page 26. Whether the suit is maintainable. So in this regard, the learned court held that yes, the suit is maintainable. That is the whether second thing, whether the defendant made contract to sell the land mentioned in Schedule A to the plaintiff and also executed a deed of agreement for sale bearing number 1762 2005. So this was discussed by the learned court. And three, whether the defendant breached the terms and conditions of the deed of agreement. So here Lordship would see the discussions have been made in various paras. It starts from para 10. The learned munship misconceived the whole law and facts involved in the suit and passed an illegal decree. That was the grounds taken by them. Now the court's finding, Lordship would see page 28.
So, Mr. Mahmood, you say in paragraph number 15, the first appellate court has formulated the point for determination.
Yes.
And there is a discussion on that point.
Discussion on the point for determination whether the judgment and decree dated 29/11/17 passed by learned munship number 1 Nogang in TS number so and so, partly decreeing the suit for recovery of money instead of granting a decree for a specific performance of contract, even after deciding the issue number 2, whether the defendant made contract to sell the land mentioned in Schedule A to the plaintiff and also executed a deed of agreement for sale bearing number so and so. So, well, this here important question arises. An agreement was executed because as we have not filed any cross appeal, so suppose we have executed, I have executed, the original defendant has died. Now his legal heirs are here before our lordship. Now, question is this, my lord, that when there are the lands in a patta of several persons' name, including his brothers and sisters. This is a very important question, my lord. I have made an agreement with the respondent that I will sell you 2 katha 5 lessa of land. But in that patta, there are the lands of my the share of my brother and sister. And there is no partition. There is no partition that this portion is my land, this portion is my brother's land, that portion is my sister's land. No such partition or separate mutation has been held with specific boundaries. Now, whether that contract is a legal contract or not, that is a question.
No, Mr. Mahmood, I have already told you that sitting in second appeal, we are not entitled to reappreciate the evidence.
Second appeal, but thing is this, my lord, in first court, the decision was regarding money, and then in the
No, you say
trial court
coming to the first substantial question of law, it relates to Order 41, Rule 31.
Yes. The learned court being the court of facts, so though reiterated in the appeal. Now, the first appellate court is also a court of law as well as facts.
One by one, you come to the substantial question of law. The learned trial court has formulated substantial question of, no,
Yeah.
sorry, point for determination. It has also discussed the issue, no, discuss the evidence on the record in respect of that issue.
Evidence
That
on
point for
record,
determination.
that is, my
And
lord,
also recorded a finding.
evidence, my lord, actually, if I say correctly, then lordship would see evidences have little discussion.
Hmm?
Evidences have been
No, whether discussion is a little or more, that cannot, that is not the question, whether there was this discussion or not.
the discussion
was
was very
discussion.
limited action, my lord, because yes, lordship,
If a
lordship,
discussion is there, then the requirement of Order 41 Rule 31 is complied with. This substantial question of law is not involved then.
no discussion so much, must, my lord, may kindly say what type of discussion
Mm,
held here.
mm,
Here, the grounds of appeal they have taken,
mm,
then the argument of the lawyer has been made both the parties, and
You
the
see, paragraph
respondent,
number 15 is the point for determination.
a point for determination, that was also I wanted that.
Therefore,
determination.
in the following paragraphs, the First Appellate Court has discussed the evidence and also arrived at a finding. So, first, this first substantial question of law appears to be not at all involved here.
No, lordship kindly see page 28 again, if it was, so far the evidence part is concerned,
Mm,
whether the judgment and decree
mm,
dated 29/11/2017
mm,
passed by landed Munship number 1 Nagang in TS number so partly decreeing the suit for recovery of money instead of granting decree for specific performance of contract, even after deciding the issue number 2, whether the defendant made contract to sell the land mentioned in Schedule A to the plaintiff and also executed a deed of agreement for sale bearing number so in favor of plaintiff, is liable to be set aside. Now, they are only, the first appellate court is discussing only that point of decision, whether it is correct or not.
mm,
But here is no discussion I see, though there are evidences adduced by both the parties, I see no discussion here.
mm.
No discussion here. Only law point he has touched. So many law points. Whether those law points are applicable in this case or not, that is another question. But kindly see discussion of evidence. Now, page 29, kindly see.
Mm.
On close scrutiny of the impugned judgment, what transpires is that the core issue involved in the suit was the issue number 2, as has been reproduced above. The said issue has been decided in favor of the plaintiff by the learned court below. It held that from the evidences tendered by the plaintiff side in respect of the agreement for sale, it is safely established that defendant agreed to sell the suit scheduled land to the plaintiff and deceived. Now, on the basis of evidence, he said, but what does the evidence say? What does the witnesses say about the ownership of the land? First, my lord, may I have executed an agreement. I have admitted that. But whether that I have any capacity to execute the agreement, I have legal right.
No, in order to appreciate your submission, then another substantial question of law has to be framed, that whether the finding of the First Appellate Court is perverse or not.
Yes,
Unless such substantial question of law is there, we cannot appreciate the evidence.
No, that is always open, lordship. Other any substantial question, if necessity arises, then lordship may frame or the parties may argue also on that point. So, first my thing is this, my lord, I have executed an agreement with the respondent. But whether I have any right to execute a valid document with respondent, because the land is in the name of several persons, several brothers, sister. So whether I can that, and there are other lands also. That's why, my lord, for a moment, I wanted to read the title suit. Kindly see for a moment, page 8. For a moment, kindly see page 8. Schedule A. Here is, I think, I see only one schedule. Now, even schedule A. 2 kathas, 5 lessas of land out of 7 bighas. 4 kathas, 7 lessas covered by the number so and so, PP number so and so. 62 PP number, Dimuruguri Kisham Moja, Nagang Assam, North Nasir Khan, South Banesa Begum, East Samed Dilwar, Opopoth, West Road. Now, 2 kata 5 lessa out of 7 bigha 4 kata. 7 bigha 4 kata, 7 lessa land. Lordship would kindly consider this aspect. Now, here is the land of 7 bigha 4 kata, 7 lessa. And this Bayananama has been executed in respect of 2 kata 5 lessa. Now, this 7 bigha 4 kata of pattern number 62. Now, for a moment, my record would be there. Here, Jamabandi, my lord, or Lordship 62. Here, Lordship would kindly see, perhaps the record is there, but I am still reading. Now, here are the names of a large number of persons, my lord. No. Can you see the patta number here? Nojukha Pita Abdul Kader. Original landowner is Abdul Kader. Here the names of Nasir Khan is there, the present appellant.
Here, Jamabandi copy is available here.
That should be there, okay. Because
Page number?
Because in the last of the judgment, it is not there, but it is marked, my lord. It is marked as exhibit 1, 2, and there revenue receipts are also there. Revenue receipts are also marked, but normally in before last at the last point of the judgment, those things are mentioned which are the exhibits. It is not here. In the first appellate court judgment and second appellate trial court judgment, my lord, also. That is not there. In the second appeal, my lord, that is page, last part is page 38. Here is also no mention of those exhibits, my lord. Page 38 and 39. No mention is there. But documents are marked. It so appears. So if it is marked, definitely it will be in record. For a moment, Lordship, I am.
Page 14, the exhibits are recorded. Page 14.
14. 1/4.
1/4.
Yes, exhibit. Now, exhibit 1 is the registered Bayananama. Exhibit 2 is the paper giving possession to the plaintiff by the defendant. Defendant exhibited following documents. Exhibit Co is the certificate copy of Jamabandi of Meyadi Patra number 62. Now, this is very important, my lord. 62. The 2 kata 5 lesser land has been proposed to be sold from Patra number 62. Now, in Patra number 62, my lord, there are the names of so many persons, including my brothers. Here, Nasir was the original executant. So, Nasir's brother is Najib Khan Abdul Kader, son of Abdul Kader. Then Kazim Khan, son of Abdul Kader. Muhammad Abdul Khan, son of Abdul Kader. Mohammad Firoza Begum, and Sami Abdul Kader. So, Lordship would see here the names of 4 brothers are there, excluding 4 brothers are there, and plus widow mother, plus widow, 5 persons are there. The owner of the lands of late Nozuka. Nozuka, who is the ancestor of the appellant and brothers. Now, these other brothers are not a party here. And at that time, land was not mutated even in their names or separate, there is no partition. Now, in the case of in hand, my lord, Fateh Chand, in the case of Fateh Chand, I am giving the application. Kindly see Fateh Chand. Dr. 14, video. Para 14, 15, and 24 may be seen. Manu SC 0258/1963. Now, Lordship may kindly see para 14. First, Lordship may kindly see page 12. 1-2. The claim made by the plaintiff to forfeit the amount of rupees 24,000 may be adjusted in the light of Section 74 of the Indian Contract Act, which in its material part provides when a contract has been broken, if a sum is named in the contract as the amount.
Which paragraph you were reading?
12.
Yes, and that is the decision.
Yes. The claim made by, Lordship has seen?
You are referring to this judgment?
Para 12.
This judgment?
Yes, Fateh Chand. Fateh Chand versus Bal Kishan.
Yeah.
Para
Paragraph
12
number
may
12.
kindly be seen.
12 is a decision in Abdul Ghani and Company versus trustee of the Port of Bombay.
This is, my lord, actually, I am saying Shobita Rani Saha. Actually, in Shobita Rani Saha's case, few days back, this judgment was referred, and ultimately the money was asked to be returned.
No, here you say in paragraph number 2 or the 12 of this decision.
12, 14, 15, 24. First,
now which paragraph you are reading?
Para 12.
Para 12.
Yes.
Okay, start from the
Para
beginning.
12. The claim made by plaintiff to forfeit the amount of rupees 24,000. Lordship has seen?
Is not available here in paragraph number
12.
Whether
that is Fateh Chand, my lord.
Paragraph number 12.
Huh? Petition for para 12. Oh, yes. Actually, judgment is the same, but paras are a little different, my lord. Sometimes it so happens, but in para 12 here, yes. Let me then clarify it. Para number 6 over negative. So, 6. Para 6. Para 6. That is a third. Cutting this up. That's it. 14 to Asile, starting the second clause.
Para 9.
Para 9. 9 that is what there. That is 15. Section 74. Alright, yeah. That is 24. 24 and 16. And 24 there. So 24 to the syllable. 24 the decree. Last part.
19 over.
Yes, 19.
19.
Yeah. So, কি হল এতে? লগে লগে কি আনিল? 12 to আসলে কিমান?
14.
12, 14, 15, 24. Judgment is the same, but paras are different. That is. Now, here para 12 ballot is research from the claim. Lordship has seen there's para 6 there.
Okay.
Lordship has seen.
Yes.
The claim made by the plaintiff to forfeit the amount of rupees 24,000 may be adjusted in the light of section 74 of the Indian Contract Act, which in its material part provides when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be, the penalty stipulated for. Then Lordship may kindly see page 14, para 14. It is the second clause. The second clause, para 14, it is from the word, the clause, the second clause. Lordship has seen? The second clause of the contract provides that if for any reason the vendee fails to get the sale deed registered by the date stipulated, the amount of rupees 25,000, 25,000, rupees 1,000 paid as earnest money, and rupees 24,000 paid out of the price on delivery of possession shall stand forfeited, and the agreement shall be deemed cancelled. The covenant for forfeiture of rupees 24,000 is manifestly a stipulation by way of penalty. Then para 15, that is section 74 of Indian Contract Act, deals with the measure of damages in two classes of cases where contract names a sum to be paid in case of breach and where the contract contains any other stipulation by way of penalty. We are in the present present case not concerned to decide whether a covenant or forfeiture or deposit for due performance of a contract falls within the first class. The measure of damages in the case of breach of a stipulation by way of penalty is by section 74, reasonable compensation not exceeding the penalty stipulated for. So that is discussed. Then after 4 lines, Lordship would see, thereby it merely dispenses with the proof of actual loss or damages. It does not justify the award of compensation when, in consequence of the breach, no legal injury at all has resulted. Because compensation or breach of contract can be awarded to make good loss or damage which necessarily arose in the usual course or things or which the parties knew when they made the contract to be likely to result from which. So here, my lord, the parties are nearby residents. And he clearly knows that I have also brothers, widow mother. So only from me they got the execution of the document. Of course, that was not proper. That is, morally, I am guilty. But legally, they are not entitled for the a specific performance of contract, accepting money. Now, that thing, Lordship, last, I will show the citation, a paragraph of the Act, my lord. Now, kindly see the last part, 24, that is, there is perhaps 19. Page, para 19. Last para. Last, not last, 3, after, before 2. The decree passed by the High Court will therefore be modified. It is ordered that the plaintiff is entitled to retain out of rupees 25,000 only rupees 1,000 received by him as earnest money, and that he is entitled to compensation at the rate of rupees 140 per mensum and interest on that sum at the rate of 6% as it accrues due month after month from June 1, 1949 till the date of delivery of possession, subject to the restriction prescribed by Order 20, Rule 12(1)(c) of the Code of Civil Procedure. Subject to this modification, this appeal will be dismissed in view of the divided successes. We direct that the parties will bear their own cost in this court. Now, my lord, when the execution of the agreement was made, they knew very well that there are so many other shareholders, but they are not the parties in this case. So, non-joiner of necessary parties, they are most important necessary parties, but they were not made parties. And second,
there is no substantial question of law on that point.
that up to your lordship, that lordship would decide. But that was framed by the Honorable High Court. We are only on that. That was the.
No, in another case, what Supreme Court has did, that is a different matter. But in your case, there is no substantial question of law on that point.
That lordship would decide.
Even the trial court has also not framed as to whether non-joinder of necessary parties will be fatal or not.
My lord, there are many instances, even the appellate court or in second appellate court, even in Supreme Court also, if necessity arises, that additional issues may be also framed. Additional issues may be also framed, and the court may decide the issue itself or may direct the court below to discuss all these 2 or 3 as the Honorable Court so directs that these additional issues may be also framed and according discussion may be made after hearing the parties.
Your submission is incorrect.
No, additional issues are framed by appellate court.
Question of appreciation of evidence will arise. This court
No, my
cannot
lord.
in second appeal.
Additional issues may be framed by appellate court. There are judgments also. If the court feels that
court may frame the additional issue and can remand the matter to the trial court or to the appellate court to decide the same.
Yes.
But in second appeal, the court cannot decide that issue by appreciating the evidence.
Well, I have one judgment in our High Court in case of one Jahanara Begum versus Sahara or like, but Jahanara is correct because Jahanara is my client. That's why I know her name better. In that case, my lord, this Honorable High Court, not by your lordship, by another honorable judge, has decided the matter and asked the court below to go through all these matters. All these matters because those were not the subject, though important subject matter of discussion, but that were not discussed. So accordingly, asked to decide, and it was directed that you file a petition under section 47 of 47(1), order 47, rule 1 and 2 of CPC, and asked. That was the order in Jahanara's case, Sufia Khatun perhaps. Now the case is pending at Borpeta Municipal Court. So I may also produce that. But my submission is this, my lord. When the parties are nearby residents, they know. Now, let me say here, the learned appellate court had made one discussion, my lord. One discussion here, lordship would say, I am going to that point. Section 44 here, this first appellate court has discussed about the provision of section 44 of Transfer of Property Act. Section 44, Transfer of Property Act, section 2045. Page 36, lordship kindly see. Page 36, section 44. Here, section 44, the learned first appellate court is saying this. Section 44 of the Transfer of Property Act says that when one of the several co-owners transfers his share, the transferee stands in the shares of the transferor. But section 44, what does it say? Lordship may kindly say TP Act. Kindly take the TP Act
Yes,
for a moment.
I'm taking it.
Then section 44 says, 44, sell on behalf of mine, section 44 is section 44. Sell on behalf of minors. Execution of sale deed denied. Sell on behalf of minors, well, it does not affect the doctrine of part performance provided the purchaser proves the compliance of necessary conditions provided in section 53 of the Transfer of Property Act. So, this section does not reflect here.
No, section 44 is different for getting something else. This is section 44.
Section 44. Let me get this. 44.
Section 44 says transfer by one co-owner.
Co-owner.
Yes. Very
Yes,
much relevant.
Yes, section 44. Sorry, I am actually I was not properly found out. Transfer by one co-owner where one of two or more co-owners of immovable property legally competent in that behalf transfers his share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transferor's right to joint possession or other common or part enjoyment of the property and to enforce a partition of the same by, but subject to the conditions and liabilities affecting at the date of the transfer, the share or interest so transferred. Now, it is clearly stated, my lord, to give effect to transfer of the transfer right to joint possession or other common or part enjoyment of property and to enforce a partition. Now, where is the partition here? Here is no partition. So, what the
Whether you have raised that issue before the trial court and also first appellate court?
that of course,
Not raised.
my lord,
You
that
cannot
may
raise
be
that.
raised. Yes, that was raised, man. That was raised in WS. That was raised, I think, because there is WS. Lordship may kindly see.
Page number?
I'm reading. Page 9, kindly see. Page 9. Para 7. That the suit is bad for non-joiner of necessary parties. All other legal heirs, other heirs of late Abdul Qadir, namely Kasem Khan, Saleha Begum, Nur Jahan Begum, and heirs of deceased sons Najam Khan, Abul Khan, and also heirs of deceased daughters, namely Rejia Begum and Surya Begum, and all other pattadars of the suit patta land are necessary parties. All other pattadars I have not on that matter. But these are the legal heirs of late Naju Khan. Naju Khan's property, 2 katha 5 lakhs have been proposed to be sold. So necessarily, my lord, there must be a partition. And for that is why there are hundreds of cases in Gauhati are pending for NOC, my lord, because the co-pattadars, the lands are not partitioned. Unless it is partitioned, there will be vague decree upon which land the decree would be executed, my lord. Now, my lords may say one thing, that considering the patta number, in patta number so many lands are there. So this is our first in WS para 2 we have category mentioned.
But no issue has been framed
on
that point.
Issues what are framed here, I cannot go behind. What is there, I cannot go beyond that. So now I would issues. Let me submit first. Page 14.
Though it was not issued frame, but this part was discussed.
No. That cannot be. Page 14. Here are the issues. Page 14. Page 14 are the issues. Whether the suit is maintained in its present form, whether the defendant made the contract, so whether defendant breached the terms of contract, whether plaintiff is entitled for, so whether non-joiner of necessary parties in absence of partition. So that is a vital issue here. So, my lord, everything is in the interest of justice, my lord. So we have categorically stated that these are the legal heirs of late Naju Khan, and the land is in the name of 4 brothers, 1 widow mother after the death of Naju Khan. So they are neither the parties in the suit nor they are contractors. No. ইয়াতে কন্ট্রাক্ট যেটো কৰিছিলে এইটো তো এইটো মোক দিয়াচোন Now, Lordship, for a moment I invite your Lordship, kindly take the Indian Contract Act. Indian Contract Act, section 29.
Mr. Mahmood,
My lord.
you see,
It is a void contract, my lord.
Here, out of the four substantial question of law formulated by this court, you have abandoned the fourth.
Substitution of litigation.
And in respect of a substantial question of law number one,
Two, it is covered, but two. Substantial question number 2, it is covered.
but can it be a substantial question of law?
Whether the defendant appellant had the legal right to execute a registered agreement for sale in respect of land measuring 2 kathas 5 lesas covered by dag number so and so, pata number so and so, Dimuriguri so and so, when there are many other co-pattadars owners. Not only co-pattadar, I am forgetting about co-pattadars because in a patta 100 persons name may be there, but owners are there.
Maybe, but the question is whether it is a substantial question of law.
In my opinion, it should be because that is
your opinion will not
pertinent
matter.
question. Though there is a pertinent question, my lord. We are 4 brothers. We are living in the same house, and one brother is selling his part.
Whether similar kind of disputes are not earlier dealt with by the court.
No, my lord. In my opinion, my lord,
No, substantial question of law.
we shall not discuss.
Not only be a question of law,
Yes,
but
in one or
substantial.
substantial question of law is this, that which is important law points but not discussed by courts below. Not discussed
Therefore,
or decided.
Therefore,
Now this point is not decided.
not decided. Therefore,
Yes.
we have to frame one substantial question of law as to whether the judgment and decree passed by the trial court as well as by the first appellate court are perverse on account of non-discussion
Yes,
of the
yes, a good issue.
material.
That was not mentioned, not framed.
Formulated.
Not framed.
So we feel that such a question has to be framed to appreciate the submission advanced by you.
Fully correct. But I think there is also one point, my lord. The other substantial question maybe I think that is there.
The point number 1 may be correct. It may be involved, but the question is whether the trial court, first appellate court has directed its discussion into all the issues framed by the trial court. If there is discussion, if there is finding, then this first question of law, substantial question of law will not involve.
That is, of course, there is sometimes 2 or 3 issues may be also discussed together. There is also such type of judgments, and if the issues are totally relevant with each other and issues can be decided by common discussion. But here, my lord, this is very important thing that when there are co-owners and there is no partition admittedly, my learned friend cannot say that there was partition. How they got this land? Yes, I admit, morally I have done something wrong. But morality does not have any effect in the eye of law. If the lawful condition is not fulfilled, now an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. That is, my lord, is the interpretation of my lord, section 2. Section 2 I of the Indian Contract Act.
Okay, Mr. Datta, you also go through the decision of the first appellate court and see, both of you, see whether the learned First Appellate Court has directed discussion in respect of the issues framed by the trial court or not. If it was discussed, of course, no, only one point for determination was formulated by the First Appellate Court. But there is a decision of Supreme Court. You take it down, the citation. Civil Appeal number 16956. Dash 16957 of 2017. The name of the parties are Mugendo, Indravan Mehta and others versus Ahmedabad Municipal Corporation.
Civil appeal number.
Civil. Mugendo Indravan Mehta versus Ahmedabad Municipal Corporation. There, in paragraph number 30, para 30, Supreme Court has stated that even if the First Appellate Court does not separately frame the point for determination arising in the first appeal, it would not prove fatal as long as the court deals with all the issues that actually arise for deliberation in the appeal. Substantial compliance with the mandate of Order 41, Rule 31 CPC is that, no, in that regard is sufficient.
Yes, true.
So here, the first one is those, the order and rule has not been mentioned. It is under Order 41, Rule 31.
Yes.
So you see whether there is discussion or not. If there is discussion,
Yes.
then it would be substantial compliance of this rule, order and rule.
Yes, sir.
Then the first substantial question of law will not arise here.
In fact, my lord, it has been discussed. That was
Therefore,
that I would have submitted. I've gone through it. Lord. It has been discussed. Every issue has been discussed. What my lord, my learned friend is trying to indicate, my lord, is that these issues were not discussed. Were all discussed, my lord. In fact, on the point of non-joinder, what had happened, my lord, two important aspects of this matter, my lord. Both of them are concurrent findings. First of all, there was an agreement between the plaintiff and the defendant. That has been, my lord, found by both the courts. Secondly, my lord, there was an agreement, my lord, or handing over of possession to me, my lord. Both the courts have agreed. The first court differed on the ground that there are other parties. Therefore, it says I cannot decree specific performance. You will be entitled to get back the money. But the appellate court said, first appellate court said no. Every aspect of the transaction has been fulfilled, and in spite of there being other parties, I have judgments to place. In spite of there being other parties to this particular land, the agreement says he has specifically marked in bold, Moor Nizamati. What he sold was his own land, and court came to a finding that though there were other owners, I am the dominus litis. I am the person who was to make the party. And in the absence of other parties, even under Mohammedan law, it is permissible for this person, for the plaintiff, to sold this property to me. In fact, what had happened, my lord, other parties have not approached this the honorable court, saying that we are necessary parties. He himself did the agreement. He himself made the agreement with me. And then when he says...
Whether that plea can be sustainable or not.
Yes. Which plea, madam?
Not that plea. The affected parties have not approached the court.
Yes. Not approached. He himself did, executed the agreement. And then when it came to performance, he said, no, I cannot perform because there are other parties. It was his own way to wriggle out of the agreement. Therefore, under Mohammedan law, I have a case law of our Honorable High Court, and there is a judgment of Supreme Court which says that in a decree for specific performance, it is between me and the person who executed the agreement. It is me who has the right to decide who is to be made a party. And so far as my learned friend was reading section 44. Section 44 of the Transfer Property Act says, if there are other sharers, more than one co-owner, if a person sells his share of the property, I am entitled to seek partition against the other co-owners. So what has happened here, and if your lordship just looks at this particular, just one line of the judgment of the London Appellate Court. He has marked it in bold, page 34. Well, he writes about from 4 or 5 lines to the top.
Yes, got it.
There is a crystal recital in the agreement for say Exhibit 1
that the land agreed to be sold as shown in the schedule to the agreement for sale, that is the suit land, measuring 2.5 meter is owned and possessed by the defendant. In SMS language, it was written as more needs namio, needs hok sotto or dokolia, topsil bornito dui kotha pasle samati, thereby meaning that the sale land was in the name of the defendant alone, and he was possessing at the same time at the agreement for sale. Nowhere it has been mentioned that this in Exhibit 1 that the said 2/5 meters land was jointly owned by the defendant with other siblings, etc., as contained by the defendant. And as I have already said, your Lordship, other parties have not approached saying that no, we have our rights have been violated by this agreement. They have not approached. He himself executed the agreement, and when it came to performance of the agreement, he realized that this land will be fetching much more value. So therefore, he backed out of the agreement. Now he started saying, no, I have my brothers and all. Who did not make the argument? My learned friend was saying that morally I did something wrong. But what he did was legally permissible in law. Therefore, it was not just a moral wrong. He was correct in doing it because he said it is his own land, first of all. Even for assuming for argument's sake that there is some other, it is not correct position. Even then, there was nothing wrong in this sale. And more importantly, other persons who are his brothers and sisters, or even his mother, who might have been alive at that point of time, they did not come forward and say,
No, that's all right. In a specific performance of contract,
yes, ma'am.
it is only between the parties who entered into the agreement.
Yes,
The others are not necessary party. There is a decision of Supreme Court.
No, here, my lord, what my learned friend has read,
that
that
Kasturi,
owned and possessed by me, this is not correct. Owned and possessed by me, it is under joint possession. And I could not execute the agreement because of objection of the co-sharers. When execution was, Bananama was executed, at that time they were unknown. But when the question came that money should be returned because of this and that, there is also no, you cannot sell this because. So whether they have come or not, raising their issues that we are also the co-owners, that information I do not have at present.
So, Mr. Mahmood, this second substantial question of law is also not involved because in specific performance of contract, only those are necessary party who have entered into the agreement.
Yes.
Here, you and he entered into the agreement. So, you are the necessary parties, not the others.
Others,
There is a decision of three judgments,
the land is
decision
not
of Supreme
partitioned.
Court.
Here I am saying that my own and possessed land.
Yes, my lord. Santosh Hegde, Tarun Chatterjee, and P.K. Balasubramanian, my lord.
Yes.
Yes, my lord. Para 15, my lord. Sorry, but before that, there are other paras also. My lord, para 15 and 17 can be read. That apart, the plain reading of the expression under so-and-so under sub-rule 2 of order 1, rule 10 of CPC, all questions involved suit in abundantly clear. The legislator clearly meant that the controversies raised between the parties to the litigation must be gone into only. That is to say, controversies with regard to the right which is set up in the relief claim of the other one side and denied on the other, and not controversies which may have arisen between the plaintiff and the appellant and the defendants in terms of the questions between the parties to the suit and the third party. Then, my lord, para 17. That apart, there is another principle which cannot also be forgotten. The applicant who has filed the instant suit for specific performance of the contract for sale is the dominus litis and cannot be forced to add parties against whom he does not want to fight unless it is a compulsion of the rule of law, and as already discussed above. For the aforesaid reasons, we are therefore of the view that respondent 1 and 4 to 11 are neither necessary parties nor proper parties, and therefore they are not entitled to be added as party defendants in the pending suit for specific performance of the contract for sale. So here third parties came, here third parties have not come also. He himself is saying, I executed the agreement, but now I cannot enforce it because there are my brothers, sisters who were there. So he took the money, he took everything, and then he says, no, I cannot execute the agreement. So he is resigning from the contract. And in the Mohammedan law, there's another decision of our court, that I'm placing, that is, in my lord, RSA 47 2007, my lord, para 18, my lord. In page 4, my lord, last para. In respect of substantial question of law number 2, it appears that from the provision of section 14 principles of moral law written by Din Shah Khatunji Mullah, 20th edition, that on the death of Muhammadan, his all estate devolves on the heirs at the moment of his death, and his heirs succeed to the estate as tenants in common in specific shares. Therefore, the court does not find that there is any bar in claiming partition in respect to properties held in common without seeking partition of all the properties. Be that as it may appear, the pro forma defendant number 2 and 3 and their mothers were examined as PW 1 and 2 and respectively could show from their evidence to the effect the plea of that the suit was partition among them could be discarded. It thus appears from Sufia Begum and so were examined that had been in the sale of the land to respond number 1 and delivered possession of the suit to respond number 1. Accordingly, this court is inclined to hold that the learned first appellate court has not committed an error in appreciating the evidence issue number 6 and 7 by holding that a co-owner can sell his property to the extent of his share. Moreover, as discussed above, there is no material to hold that the sale deed was in question was fraudulent or illegal manner or in illegal manner whatsoever. So here, my lord, both the courts came to a finding that the agreement was indeed executed. Secondly, the possession was handed over to me. And therefore, my lord, this judgment is also in my favor. It says that, my lord, even if there is no partition, it can be, my lord, done. And section 44 makes it very clear. If I have, my lord, purchased the property, that the agreement doesn't become void or doesn't become bad. I can, my lord, if necessary, I can claim partition with the other co-owners with regard to that property. That's what section 44 says, my lord. Section 44 will not says when one of 44 of them will transfer property, transfer the owner. If I done it, a senior friend of surrender.
Yes.
Where one or two or more co-owners of immovable property legally competent in that behalf transfers his share of such property or interest therein, the transferee acquires as to such share or interest so far as it necessary to give effect to the transfer. The transferor's right to join possession or other common part or part enjoyment of the property and to enforce the partition of the same. So therefore, I inherit his part and I can enforce the partition against the other co-owners if necessary. Here, that question is also going to arise in because the other parties have never come and said that no, we have also shared in this particular 2 kata 5 acres land which my brother had sold to you. Therefore, we want partition. That is not the case. He himself is saying, I have brothers, therefore I cannot execute this agreement anymore. But that is also not his case. My learned friend was trying to make a submission that when it came to sharing of money, etc., then they objected. That is not his case in the written statement. He simply took the plea that there are other brothers and sisters. Now I cannot execute the agreement of sale because he realized perhaps that this will be fetching more money if I sell it to someone else. Therefore, he was backing out of the agreement. So therefore, first of all, my lord, as held by the Supreme Court, my lord, that in a partition suit, my lord, the suit for specific performance, me and the person against whom I'm seeking the performance, they are the necessary parties. They are very much there here, so there is no dispute there. Secondly, I have shown in Mohammedan law, and the Mohammedan law, they can do mal. It can be sold, even if there are other co-owners, as has been held by Honorable High Court. And section 44 is also very clear on this subject. So therefore, this, my lord, that because there are other legal layers, this agreement could not have been executed, is totally incorrect. And therefore, the first appellate court was absolutely right, my lord. It discussed all the issues. It discussed, my lord, how the parties will not got that the agreement was executed, that the possession was held given by Exhibit 2, and then it also discussed even what the witnesses say, how this agreement was executed. Everything was discussed, and thereafter taking into account section 44 of the Transfer Property Act, the Honorable Court came to a specific finding that there is nothing wrong in the agreement and it can be executed. Therefore, the first appellate court, the trial court's judgment, to the extent that he refused to give me the specific documents, rather agreed to return the money, rather decreed for return of the money, that was interfered with, and the Honorable Court said, no, I am entitled to the execution of the decree, And it also came to a finding that, it concurred rather, with the finding of the trial court that I'm already in possession of the suit land. So therefore, if your honor looks at the judgment, reads the judgment, by learned friend has only partially read the judgment. If your honor lordship looks at the judgment, the lordship will find that each and every aspect has been decided. That substantial compliance and lordship judgment that lordship was referring to, that has been complied with. It had referred, the first appellate court had discussed all the points, right from the other co-owners, right to the other co-owners, and whether they're necessary parties to the suit, whether the agreement was executed, whether the possession was handed over, and whether I'm entitled to the specific performance of the contract. Everything has been discussed. Everything, every issue has been discussed. Though it only said only one issue, whether the learned trial court in page 28, if I'm not wrong, the learned trial court was, yes, the first appellate court formulated this, whether the judgment and dictated is so and so, page 28, passed by the learned municip number 1, Mogao, partly declaring the suit for recovery instead of granting us date of specific performance of the contract, even after the deciding the issue number 2. Whether the defendant made a contract to the sale of the land mentioned in schedule of the plaintiff and also executed the deed of agreement for sale bearing number so and so in plaintiff is liable to be reversed. And the plaintiff is entitled to a decree for specific performance of the contract as was prayed for. So what the learned trial court basically held was that agreement has been executed, possession has been given, but since there are other co-owners, I cannot get a specific performance. The appellate court reversed it to that extent only, because other two are already concurred. Only that extent was reversed, because the trial court found that under the Mohammedan law as well as under section 44, such was permissible, and there is nothing called, this case is not bad for non-joinder, because as your lordship has also seen that that free-bench judgment, it says it is for specific performance, only the performer and the person who is aggrieved by non-performance are the necessary parties. So, and here, as I've said, my lord, no third party claim that no, this agreement is bad. Had it been a case of some third party claiming, his brothers claiming, things might have been different. But here his brothers are not claiming, no, this property is not partition, or this is not his. He came, he executed the agreement, and then when it came to performance, he started saying, no, I have my brothers and sisters who are also owners of the land, therefore I cannot execute this agreement. I cannot perform this, execute the sale deed on the basis of this. So it is basically he who resigned, and he took a very, he got a ground, he got a very good ground, perhaps he thought that I can, by taking this plea, there are brothers and sisters, I will not perform this agreement. So it was basically a fraud on his part.
And you say
My lord,
this
I have one
point number.
submission. Even, my lord, the decree cannot be executed. Kindly see page 25 of the RSA. Page 25 of RSA. I have so many judgments also. Of course, today I have committed some wrongs.
Okay, you come prepared.
Only one point I have showing your lordship. Page 25 of the RSA, kindly see. 2 kathas 5 lesas of land out of 7 mega 4 kathas 7 lesa land. Now boundary is given Nasir Khan. He is the executant of the deed. My lord. Now then south Banesa Begum, east Samed Dilwar and Upopoth, west road. Now lordship, kindly see the patta. None of these persons' names are Nasir is the executant. His name is there. Najik in the boundary there is not his name. Kazim not his name. Abdul Khan not his name. Firoza Begum not her name. So it means that it is the land of whole 7 biga 4 kata 7 lesa land.
No, that will be looked into by the executing court, not by this court.
That is not even pleaded anywhere, my lord. That this is
No, it is your it is your case. It is your case. I am telling his case. He has mentioned the boundary, but in the boundaries none of the other legal heirs' name is there. Why? Because suppose I have sold 2 kata 5 lessa of land. But there is land of 7 biga, 4 kata, 7 lessa land. Definitely there would be our names, but our names are not there.
We are already, my lord, in possession of the land, because that's why I filed a miscellaneous.
So the identity of the land,
Last
your
year.
lordship has rightly said, that is the lookout of the executive court, it is correct. But here the drafting itself is wrong, my lord.
That is as per the agreement, my lord, whatever the agreement is there.
The agreement is wrong. That is why agreement is wrong. So we'll.
It is not the plea there, my lord.
My lord,
You cannot take up the.
no. Sometimes in second appeal also some new pleas may be taken. There are division bench judgment of our high court, my lord. Sometimes new plea can be raised.
Yes.
Sometimes that is judgment, a division bench judgment of our high court is there. Sometimes new plea can be raised in even second appeal. Second appeal in appellate court. So writ petitions matter is in discussing the writ appeal, the Honorable Division Bench held, my Lord Justice Bijesh Kumar. His observation was that new plea may be raised if it is holding the field. So here we have so many judgments in this regard. If the
Okay.
necessary parties are
You
not
bring
met,
it on next date, we will consider it.
yes, my lord.
My lord,
But,
my lord, it will part of, my lord.
Okay.
The lordship is heard it to the leg, my lord.
Okay.
Part of, my lord.
But you come prepared whether the first appellate court has discussed all the issues that has been framed by the learned trial court or
I'll
not.
address, well.
On next date, both of you have to address.
Yeah, I
on this
will,
point.
I'll argue, my-
actually
And,
thoroughly I will.
Mahmood, you see, there are 4 substantial questions of law. Fourth one, you have abandoned. There remains 3. 2 and 3 are related, interrelated.
Yes.
And if the other brothers are not necessary party in the agreement you have entered into, then the 2 and 3 also gone. There remains only 1. If the first appellate court has discussed all the issues and assigned a reason and arrived at a finding, then first one also gone.
That I will say also the other at a prepared time.
Okay. Heard.
Because
Can you not take
I have
on reopening 21st,
21st of this month.
Heard.
after reopening?
Mr. Mahmood, learned counsel for the
Let
appellant.
it be fixed on May, my lord. In last part of April, so many cases are fixed. In May,
Emma Patarajana, 1 month is within 1 month. No?
Okay, in the after Bihu, less numbers of cases are fixed. So it would be advisable to hear the matter immediately after reopening of the application.
That's why I pray for 21st, fellow.
Huh?
21st is a Tuesday, my lord.
Heard Mr. Mamun, learned counsel for the appellant, Mr. M. Dutta, learned counsel for the respondent. Heard in part, this the matter on 21st of April as part heard.
number 30. All right.
May it please your lordship. Your lordship kindly accommodate us today, your lordship. Due to medical urgency, my senior had to leave early, your lordship.
Oh, why don't you mention the matter at 2 p.m.?
Lordship, as per instructions, I waited.
As per instruction?
Yes, your lordship.
At what time your senior left the court?
Your lordship at 11:30 or 11:15, your lordship.
11:30.
Yes, your lordship.
Then you could have mentioned it at 2 o'clock.
Yes.
Hmm?
Your lordship, I have informed the other side. your lordship.
My lord, this matter may be taken up immediately after revocation on 21st of April.
As agreed by learned advocates of both the parties, recessal is the matter.
Interim may be continued, your lordship.
Is the matter on cover fixated. It is made clear that no further adjournment will be granted in this matter. Else, the interim order passed earlier will be vacated.
Oblige you.
Till then, interim order stands extended.
Oblige you.
Item 25.
So can we complete the matter today? We
My
have
lord,
only few.
if your lordship, can you allow me, my lord? My lord, while preparing the case, my lord, I felt that additional substantial question of law may be required to properly adjudicate the case, my lord.
Hmm.
Why, my lord? This is a case for recovery of loan, my lord.
Recovery of loan.
Loan amounting to the principal amount was 90,000, and the
It was
interest,
earlier a money suit before the trial court.
my lord.
It was a money suit before the trial court.
Yes. It was
And
money
trial
suit.
court has decreed the suit.
Decreed the suit, a concurrent finding, my lord. Concurrent finding.
Appellate court also upheld
Also
the same.
upheld the finding.
There is concurrent finding.
Concurrent finding. But my lord, here, my lord, the loan was advanced by way of executing a bond, my lord. That is Exhibit 1, my lord. Exhibit 1 is a bond, my lord. On, my lord, 21/6/2016, this honorable court has admitted this second appeal, my lord, by formulating substantial question of law regarding the admissibility of Exhibit 1, as it was not properly stamped, my lord. This was this honorable court also granted us liberty to raise additional substantial question of law if it is required, my lord. Now, my lord, what happens here? While I was preparing the case, my lord, since it was a loan, my lord, by way executing a bond, my lord, there is a legal impediment under Section 7D of Assam Moneylenders Act, my lord. I may be supplied the copy of the act, my lord. Pardon. Page 3, my lord. Last portion, my lord.
Section
7D.
7D. Okay.
No suit for recovery of a loan advanced by moneylender shall proceed in civil court until the court satisfied that he holds a valid registration certificate or that he is not required to have a registration certificate by reason of the fact that he does not carry.
Mr. Sharma, you see, we have to see who is moneylender.
My lord. My lord.
Where it is defined?
My lord. Moneylender is defined, my lord, in the act, my lord, principles act, my lord. The loan also defined, my lord.
Section?
My lord, this is the amendment act, my lord. I may be supply another copy, my lord. It was amended again on the principal act was amended again on in the year 1948, my lord. The definition of moneylender means, my lord, any person, including any company, association, or body of individuals, whether incorporated or not, who grants loan. And loan has been defined, my lord, in subsection A, my lord. Loan means any advance, whether of money or in kind.
No. In the original definition of moneylender,
my lord,
it is stated that in the regular course of business,
my lord,
whether the person herein,
my lord,
in
or
regular course of business,
yes, my lord,
he offered the loan or he lent the money.
My lord, for that, my lord, since it was the loan was advanced by way of executing a bond, my lord, the definition squarely covers the loan definition given in the Assam Money Lenders Act.
In order
Yes,
to
my lord. Yes, my
become
lord.
a money lender,
Yes, my lord.
he must have to do it in the regular course of business.
Regular
Was it
course
his business?
My lord, if he does not do it in regular course of business, then the certificate is not required. And for that, my lord, the observation as required under Section 7D is required.
You see, where is your pleading then?
My lord, my pleading was not there.
Then can you introduce a new fact in the second appeal?
No, my lord, kindly see, my lord. Here, what happened? I was barred from filing written statement, my lord, but the learned trial court has allowed me to participate.
Yes.
Allow
What
me
is
to participate.
your stand then?
Now, my lord, I know, my lord, since I was barred from filing of written statement, my
Hmm.
lord, so there is no way I can raise
Any plea?
plea, my lord.
Hmm.
So, my lord, this was till the case of my lord Kaushik Nasreen Bhai Patel and Messrs. SJR Prime Corporation Private Limited, my lord.
Hmm.
Here, my lord, Honorable Supreme Court in paragraph 8, my lord,
Hmm.
has stated, even if I am barred from filing written statement, my
Hmm.
lord, my lord.
No, there is no dispute about that proposition that you can participate in the proceeding.
Yes, 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 yes.
Yes.
That does not bar me from
Hmm.
raising legal question, my lord.
Hmm. Yes. Hmm.
That doesn't bar me from legal question, and this is a purely question
No,
of law.
now you see, you are raising the issue,
Yes, my lord.
but there is no pleading.
There is no
There is no evidence.
no evidence.
Now, how can you establish that in a regular course of business, he lent the money without certificate?
Unfortunately, I don't have any material.
Then you tell me where is your case? One decision of the Supreme Court is that.
Fair, my lord. Then I have to be fair, my lord. Since it is my duty to assist this honorable court, my lord, regarding the issue number 1, my lord, substantial question of law, which was framed by
Only this exhibit 1.
yes, exhibit 1, that has been discussed by the first appellate court. Already been discussed. Otherwise, I don't have any case, except this point of law.
No, is it your case that exhibit 1 is not admissible?
Not properly summed, since it was not properly stamped, that's why it is not admissible. And discussion has been made by the first appellate court itself.
No, is there any law that a bond has to be properly stamped?
I think, my lord, section 30, 36 of the Indian Stamp Act.
Section 35 and 36, my lord, exception is section 36 law.
My lord.
As per section 36 law sheet, if the, my lord, document is, my lord, instrument is law sheet, put into admission law sheet, it is already admitted, then exception is there. But the 36 is not admissible, but once admitted, exception is there. So in this case, the exhibit 1 was admitted and it was thoroughly discussed in the judgment.
Yes.
And the Lanet trial court also reviewed and asked to pay, determined the lordship stamp value, and that was paid. Then it was proceeded.
Stamp was paid.
Yes.
Stamp was paid.
Then
I say, my lord, I don't have any, except this question of law, my lord.
Then where is the substantial question of law?
My lord.
If stamp was paid later on, where that averment is there? Stamp was paid later on.
My lord, page 23 also.
Not, my lord, 23, observation is at page 25, my lord. Internal page, page 25, my lord, paragraph 19. Observation.
I will be ignoring it.
Yeah, আমি বড় আমি
Now, married loss. The London Council for the Appellants Defendant has contended that the exhibit 1 is a bond which has to be stamped as such. The London trial court had committed an error in admitting the improperly stamped exhibit 1 and further had committed an error in directing the elective respondent to pay the deficit stamp fee upon the said document by order dated 3/12/2008. The Learned Counsel for the defendants appellants have contended that the Learned Trial Court could not have directed the plaintiff to pay the deficit stamp and admitted the exhibit 1 in evidence. Hence, the exhibit 1 cannot be taken into consideration. I have believed the order dated 3/12/2008 whereby the Learned Trial Court
determined the stamp upon the exhibit one and they directed the plaintiff to pay a fee of rupees 450, which was paid by the plaintiff respondent. The learned trial court again, while order dated 17/8/2009, directed that the exhibit one may be sent to the collector for determination of the proper stamp. But again, while order dated 4/10/2010, reviewed its earlier order dated 17/8/2009 and held that as because once the stamp upon the exhibit one was determined by the trial court, the stamp cannot be sent to the collector for determination of the stamp and further opinion that the document in the nature of exhibit one does not compulsorily require bond. I have perused the order and it appears that the learned trial court had exercised her powers under section 35 of the Stamp Act 1899 and admitted the exhibit one in evidence after realization of the proper stamp, and I do not find any irregularity in the state exercise of power. The section 61 of the Stamp Act 1899 gives the power to the appellate court to take into consideration such levy of duty, but in the instant case at hand, the defendant's appellants had failed to show that the trial court had realized inadequate stamp, and further there is no material on record to show that the trial court had realized inadequate stamp. As such, it is held that the trial court had acted within her jurisdiction in levying the stamp upon the exhibit one, and further had rightly admitted the exhibit one in evidence under section 35 of the Stamp Act 1899. As such, the contention of the learned counsel for the defendant's appearance that the exhibit one would not be admitted in evidence is not sustainable. Value discussed, Lordship. My Lord, in my humble submission, no fault if there are no substantial.
No substantial question of law. Okay. We'll pass the order.
Law.
Anything, Mr. Sharma? No. No. Heard, Mr. Sharma. Learned counsel for the appellate. Mr. Ahmed, learned counsel for the respondent. Argument concluded, judgment reserved.
Possible.
Deeply applies, Your Lordship. Deeply applies.